But no mention today.
Please, Lordship. Lordship, it's regarding item number 30. We have filed the objection yesterday.
Item?
But item 30. We have filed the objection yesterday, but objection
13 or 30?
30. Record may not be here. I may be permitted to call for the objection.
Lordship, I beg to mention item number 23. I'm appearing on.
Just a moment. 30. When do you want?
30 matlab he is that may be call for matlab he is
Okay, you have filed an objection. Okay, fine. Yes.
Please, item number 16,
16.
16. May please be possible for today or give a permission to take after lunch, as you like, sir.
Fine. Any urgency is there? No.
Urgent, sir?
Don't. Okay, give a date.
No urgent, no urgent.
Give a date.
Next, itself.
May I please, your Lordship? I beg to item number 23. I'm appearing on behalf of OS Mannan. Kindly feed this matter after 1 week, my lord.
All right. Yes.
Previous lord, so item number 51, my lord, is LCR has been received. This may come up for admission. Item 51.
51. It is submitted
The
that
stay of the
LTR has been received. It is the matter for admission on.
it will be on 3rd of September, my lord.
All right.
There is an interim order that may kindly
may
be continued.
All right. Interim order passed early to continue.
Bless my lord.
May I please, the Lordship, my lord. My lord, with consent of other side, my lord, I beg to mention item number 15, my lord. That may be not fixed on, my lord, 2nd September or 9 September.
All right. 9.
9.
It please, your lordship. Lordship, in the item number 60, lordship, I am the respondent number 2, and we have received a notice. Notice, lordship. I need 2 weeks time to file my reply, lordship. 6 already submitted.
Other side.
Address at web-based, I don't know, lordship, but
You have to inform if you seek time. Wait your turn.
Please, Lordship, I beg to mention item number 52. There one IA has been filed by the other side, Lordship, but we have to file our objection. We have prepared our objection. Now we are waiting for the signing, Lordship. So 1 week time kindly be granted, Lordship.
52.
52, Lordship.
All right.
20 August. Obliged, Lordship.
My pleasure, lordship. With respect to item number 44 and 45, my lord. In 44, CD was called for and I am on interim, my lord. And no CD was received, my lord. And 44, a report was called for, my lord. No report was received. (44, CD, 45 report.
CD not received, but he is an interim, my lord.
45 report was called for as there is no FIR, my lord.
44 may be fixed on 26th of August.
44 and 45.
45 report was called from OC, my lord, whether any case registered or not, my lord. This may be fixed on, my lord.
Same thing.
Same day.
Same person.
Same person.
Okay, man.
Same petitioner.
In 44, my lord, I'm interim may be continued.
Interim to continue. 44. Huh?
Much obliged.
My dear lordship, we have filed an IA for correction of the bail order passed by this honorable court. May be listed, moved unlisted today, your lordship.
Yeah, please, Lordship. Lordship, I beg to mention item number 42. The leading counsel D. Gogo has some difficulties, Lordship.
42 is along with 36 also.
36.
30 is different council, no?
42 and 36 are similar.
The council is same.
Same. Please, yes, kindly another Lordship on witness
The case.
for the case.
36 is okay, same council. All-
Available next week, my lord.
all CD received on the prayer of learned counsel for the petitioner list again on
13, my lord.
Interim is there, not pending.
the order passed earlier to continue till next date of listing. CD be retained.
Plus,
Lordship, I beg to mention an item for listing. On Monday, a connected matter has also been listed before this court on same FIR, same PS case.
Before this court.
Yes, Lordship.
All right.
I'm obliged, Lordship.
Please, your lordship. Well, item number 35, my lord. Well, I had been, Shashi Desai. I am on the, I was on interim, my lord. Let the matter come up.
Item number 54.
Lordship, as per instructions from our client, Lordship.
Your name?
K. Bhattacharya, Lordship.
Devatacharya. Mr. Woodruff.
may I please, your lordship? Well, the accused is arrested, my lordship, on 22/7/2026, getting cow slaughter act, my lordship, prevention of cow slaughter.
22/7. CD.
From Sri Bhumi, my lord. 18.
Highly obliged.
May I please, your lordship? Well, here the petitioner was arrested on the strength of an NBWA, my lord. And he was arrested on, my lord, 31/3/2026, my lord. Until date, my lord, 108 days in custody. Here what happened, my lord? The petitioner is initially, he was arrested in connection with Dhekiajuli PS case number 1 of 2025, my lord. And later on, he was released on bail. Then Sarsit submitted, my lord. And on, my lord, 30/10/2025, cognizance has been taken by the learned Chief Judicial Magistrate, my lord. And accordingly, he received summon. And after receiving summon, he has appeared each and every date before the court below, my lord. Thereafter, my lord, on 19/3/2026, my lord, page number 39, my lord. Here, my lord, and committal order was passed, and where he is present, but he was directed to appear before the learned session judge on, my lord, 31/3/2026. And on 31/3/2026, my lord, he was absent without any steps. And therefore, an NBW was issued, my lord. And on the strength of that NBW, he was arrested, my lord, on 21/4/2026. And
Only one date you were absent.
only one date, my lord. Only one date.
Let's dispose of. Third learned counsel for the petitioner,
Lovely idea.
additional PP. The petitioner is an accused in connection with. What is the case number?
My lord, Dhekiajuli PS case number 1 of 2025. Now, my lord, session case 108 of
108 of 26.
Pending before the
Session Judge Sunitpur, Tezpur.
Learned Session Judge, Sonitpur, Tezpur. It is submitted that the petitioner had been appearing regularly during the pre-committal stage and thereafter, after committal of the case to the Court of Sessions, petitioner had appeared, but subsequently on one date he failed to appear, because of which NBW was issued against him and he was arrested on the strength of such NBW on,
21/4/2026.
and since then he has spent how many?
108 days.
08 days in custody. Having regard to the above, is directed that the petitioner shall be released on bail of rupees 50,000 with 2 sureties of like amount, for the satisfaction of the learned trial court. order directed that the petitioner shall henceforth appear regularly during the course of the trial. Petition stands alone.
Item 3.
Please, Your Lordship. Also matter, Lordship, I may be allowed to take steps upon the respondent number 2.
Steps on respondent number 2.
Laluk Malak on 21st. I got no, has to be served. Deeply obliged.
But regarding misappropriation money, Milord, I make compensation, Milord, secretary. As I lost the BDO office, Milord, accountant. And in the meantime, Milord, that the person who has committed a mistake, Milord, or misappropriated the amount, Milord, he has also been arrested. So, my Lord, CD will be called only, shorted me. She is a woman, Milord.
More than 52 last Malak. CD from Bongaigaon. 20.
Can I, Milord?
I got no. ঠিক আছে বউ।
Why not? Right?
Wait, my lord. My lord, standing counsel, Mr. B. Chaudhary is appearing in this matter. Timing, my lord.
Timing.
Hey, please, Your Lord. Once the pre-arrest bail, my lord, your lordship will find the FIR, my lord, at page 8, my lord. Well, it relates to a gambling, Assam Gambling Act.
Yes.
My lord, may I read, my lord? With reference to the subject above, I beg to state that on so and so, a reliable source information was received by the OC Hatigaon PS that some unknown individuals were playing gambling at the Hotel Crown Place, France Path under Hatigaon PS jurisdiction area. After receiving the information, a GD was entered in the so and so. Therefore, thereafter, I, along with the OC, so and so, my lord, along with other PS staff, proceeded to Hotel Crown. Its address, my lord. After arriving at the hotel, we got to know that few individuals were gambling at room number 101 in the said hotel, that is Hotel Crown Villa. Accordingly, we entered into the room number 101 of Hotel Crown Villa and found that 3 persons engaged in gambling by playing cards for the stakes involved in a substantial amount of cash. On being questioned, they disclosed the identified as follows, my lord. Number Abdul Matlib Gyasuddin Ahmed, and number 3, my lord, Amir Ali, my lord. My lord, they got arrested, my lord. My lord, during search conducted, my lord,
Who are you?
my lord, I have narrated the fact, my lord, if your lordship pleases to see, my lord, at page 4, paragraph 5, my lord. Admittedly, I went there, my lord, but for not playing cards, man. Page 4,
Let him
paragraph.
appear before the Pardon counsel for the petitioner on an additional PP. Application under so and so. Allegation. That paragraph 3 is that or not? It is submitted that the present petitioner is a businessman by profession. This Amir Ali is one of the arrested.
Yes, ma'am.
One of the accused, Amir Ali, called him to the hotel. Take the balance of the money that was due to the petitioner account of sale of a second hand car. But after arriving there, he heard that the said accused has been arrested. It admitted that petitioner is no way connected to the offense. But yet the police is searching for him and even visited his residence. Do we call for the CD or
Maybe CD may be called for Malapur.
the CD?
Something else may be there.
In the, it is provided that in the event of his arrest, the petition
Start of September, Malapur.
shall be released on interim bail of rupees
I'm obliged.
50,000 with
Deeply
security of like amount satisfied. Testing authority. It's further provided that the petitioner shall appear before the IO within a period of 10 days from today. Cooperate with the investigation.
My lord, it's a NDPS diary at this stage, madam.
6.
Malat, 21st.
I'm obliged.
After some time.
May I please, Your Worship? My lord, it's a pre-arrest bail application. FIR Lordship will find at page 13. One must. On a tip off, my lord, the house has been raided of Mr. Dulaluddin, that he has concealed one 9mm pistol nearby to his water pump, my lord. Page 13, my lord. Later on, the investigating officer found that he is not involved, rather one person.
It was conducted in the house of Dulaluddin.
Yes, on a tip off, my lord, and it was recovered from the Dulaluddin house on the basis of Shah Jamal Ali's statement. And the Shah Jamal, later on it was found, actually Shah Jamal Ali, he has concealed the pistol without the knowledge of Dulal.
So who are you?
So, my lord, when he arrested Shah Jamal, because he now implicated me as per the police as when they came to my residence, they has informed my family members that the Shah Jamal later on implicated me. Initially, he implicated Dulal, then he has also started implicating me. He was arrested. Page 18 is the forwarding of the Shah Jamal.
Page
18. He was arrested. He is the kingpin, my lord. Just to because he was arrested, he made a false allegation about me and Dulal.
no, from the forwarding report does not mention you.
Yes, yes, doesn't mention me.
So from where from you get that apprehension? No.
Because the police visited my residence, my lord, that the Shah Jamal, he has implicated Dulal as well as me. That is the information. That's why I'm apprehending, my lord, that I have specifically stated in my petition also. So I'll cooperate with the investigation, my lord. if there is anything comes out in the CD, always can reject my application.
I'm saying, at this stage, only city may be called from Nagaon, I'll produce next week. 17 or 18.
No, nothing was I recovered from him it seems.
Yes, that is there. Actually, it was found from the house of Dulal. How Shahjal come into the picture. So his rule also may be there. We don't know at this stage without producing the CD.
Because Shahjamal has implicated me, that is the, and he has made false statement regarding the Dural also, and he has concealed the in the Dulal's house. to
Whether
implicate.
Shahjamal put it on the people of the Dulal's house, or Dulal himself put,
That is in the FIR. That is in the FIR itself. It is your FIR. It's not my FIR. You have stated that the Shahjamal has
We are
implicated.
now only concerned with role of
Statement of the Shahjamal.
Lal, you have exonerated. Lal, you have exonerated, although finding it there
Yes, yes.
on the basis of the statement of
the Shahjamal.
Shahjaman itself.
Now,
So whatever implication against him will be only on the basis of statement now.
that is.
So
Perhaps it was brought from the him.
other than the statement, probably there will be nothing more. Mr. M. Bonal, Senior Counsel. Said by so and so. Traditional PP decision application under so. As per the facts reflected in the FIR, one firearm was recovered from the house of one Dulaluddin by the police after receiving a tip off. But subsequent investigation revealed that it was another accused, Jamal Ali, who had placed the firearm in the house compound of the Said Dulaluddin, and was subsequently arrested. Full stop. Senior counsel submits that the police are searching for the present petitioner, who, according to police, has been named by the arrested accused. Falsely named by the arrested accused. Call for the CD. Where prima facie it appears that the petitioner has been implicated. The statement of a co-accused. Stop. Having regard to the same, it is provided that in the event of his arrest, so and so shall be released on interim pre-arrest bail of rupees 50,000 with two sureties of like amount to the satisfaction of the testing authority. Connection with the aforesaid case, further directed that the petitioner shall appear before the IO within a period of 10 days from today and cooperate with the investigation. List again on. This is learned the additional PP. Poses the prayer for interim. Prayer for interim bill.
May it please your lordship. Lordship, this is a PRS bail application here. This Yeah, the petitioner is not named in the FIR, Lordship. Kindly peruse the FIR that is on page 15, Lordship. One person specifically named in the FIR, he was arrested, subsequently released on bail. These two present petitioner, Lordship, are the member of a Lordship, all Bodo Student Union, Lordship. One holding Lordship secretary and another holding the secretary.
Let's see the FI first. That is.
Yes, Lordship, that is on page 15, Lordship.
I think we have called for the CD of this case in another case. Fixed on. I remember this.
These two petitioners are not involved in
I
this
think it
case,
is
because
next week only. Just check. I think it CD is fixed for next week itself.
some protection is a pre-arrest bail application, Lordship. They are the member of a all Bodo Student Union, Lordship. They have nothing to do because the person who has come, Lordship, the recovery was made him and he has come to in search of that person, Lordship, a petitioner, informant husband, Lordship. He is supplier of drugs in the local, in the Arunachal area, Lordship. That's why, Lordship.
15%.
But these two, there is no specific allegation against this petitioner. They were called to nab that person, Lordship. Accordingly, they went there, Lordship. They have not participated in this case, Lordship. The person, Lordship, Gomez, Lordship, his bail, I have annexed, Lordship, bail order that is on page 21, Lordship. Some protection, Lordship, they are the student, Lordship. They are the member of this Bodo Student Union, Lordship. I've annexed the letterhead also, Lordship, that is on page 20, Lordship. Letterhead, Lordship, will find their name, Lordship. Page 20 is the letterhead, Lordship. Petitioner 1 is the Assistant General Secretary, Lordship, and Petitioner 2 is the Game Secretary, Lordship.
I think it is AB 1777 of 26. Kaling Tatak. It is fixed on 3rd, I think. Yes. 21.
177 of 20.
26. Any interim is passed in that case?
But these two petitioners, Lordship, they are not involved in this case. Their name is not there in the FIR, Lordship. Arunachali people, Lordship, came from that place, Lordship. They are in a warrior group, lordship, or the anti-drugs warrior group.
Yes, yes. There was terror in the area. You were firing and everywhere.
And they have, lordship, gone with the person who is named in the FIR, he has fired, lordship.
Oh, so
That
it
is in
makes
the-
you an accomplice. You accompanied them.
We have not participated, lordship.
Don't know. Yes. Otherwise, you would not have been here. Yes. Same date. Along with AB 1777 of 26.
Complex. Wait, please, your lordship. My lord, the matter relates to, my lord, utilization of, my lord, input tax credit. And availing, my lord, that ITC fraudulently. My lord, I am working as an employee of the said firm, your lordship. My lord, in GST, your lordship, if amount is up to 5 crore, your lordship, then it is bailable and non-cognizable. If it is above 5 crore, then it is non-bailable and cognizable, my lord. And the maximum punishment is, my lord, 5 years. So, my lord, here in the case, although I have not been, my lord, kindly see complaint, page 18, your lordship. Page 19, your lordship, may kindly see. Starts from para 4, your lordship. Page 19, para 4. That preliminary investigation analysis have revealed that Sri so-and-so has knowingly willfully availed fraudulent ITC for non-exist and bogus taxpayer involving rupees so-and-so. So allegation is, my lord, against, my lord, proprietor of the firm, your lordship. And proprietor of this firm, he has already been arrested by the GST authority, your lordship. So far as I am concerned, my lord, in the complaint, your lordship will find not a single line against me, your lordship. But although notice has been issued to me, and I want to cooperate, ultimately, GST Act is for the purpose of collection of tax. And my lord, I will.
Where is that notice?
Notice, my lord, kindly see page 26, my lord. On 29, I prayed for time so that, my lord, if I will go, my lord, protection may be given, your lordship. I will go and participate in that proceeding, your lordship. And decisions are there, my lord. I am not troubling your lordship, right from Punjab and Haryana, Radhika Agrawal and all. My lord, unless and until, my lord, tax amount has not been determined by, my lord, assessing authority, we cannot say that, my lord, this is the amount.
So which amount would they go by for the
My lord,
determining the limit, 5 crore?
5 crore.
They
But
have to
I am
go by
so far-
whatever their
my lord,
calculation is.
So far I am concerned, my lord, I was working in his firm. I am not the proprietor of that firm. And proprietor of that firm has already been arrested and everything is documented, your lordship. If my involvement is there, certainly I will. For that, my lord, it is required that I should cooperate and participate in the proceeding. The ultimate purpose of the investigation is to know the actual fact. Since I was working in the firm, so I will go. It is not that I will not, but protection may be given, my lord, because my proprietor, he was arrested, so I have apprehension, my lord.
Of that. And also, though the proprietor is inside, he is also an employee. He will be knowing. Thereafter, lordship may.
He has been given a date, I think.
My lord, on that day, I have given, my lord, prayed for time, your lordship, and next week the matter I have been called, my lord.
Any date?
For Wednesday. Tuesday next. Hello, I will go, my lord.
Monday.
Monday. All right. Fair enough.
I am told, my lord, subject to what my client is.
You can seek another date.
My lord, will do.
Is on the prayer of pending council finance. CST. Is the matter again on Monday in order to enable learned counsel.
Deeply obliged.
May I plead your lordship? Lordship, application under section 482 of BNSS, allegation under section 64 of BNS and section 4 of POCSO Act, your lordship. Notice may be issued upon respondent number 2 and TCR may be called for. The matter may be pending before SPCL Judge POCSO Lakhimpur, your lordship. Next date
Mention
for
করে দিব স্পেশাল জাজ পক্সো নোটিস টু রেসপন্ডেন্ট নাম্বার TCR টু তারপরে কল করব
possible lordship before 20, your lordship. Next date for appearance 28 2000
28
208.
yes what is
If
the
possible,
point
lordship.
उसी के date what will happen notice will not come within such a short time you can seek another date there what is the
Obliged.
May it please your lordship. My lord, page 8 is the FIR, my lord. Lordship has earlier dealt with this matter, my lord, and granted bail. Of course, those persons were arrested, my lord. Here pre-arrest bail, my lord. Actually, my lord, allegation is that, my lord, attempt to commit dacoity. Actually, my lord, the fact of the matter is that, my lord, they were having my lord, some party in the roadside, my lord. Then some altercation took place between them. Then they were arrested, my lord. And my lord, the petitioner, my lord, he is for pre-arrest bail. But that is me, my lord. That is me, my lord. Because my lord, but there is no allegation of commission of any dacoity or like that, my lord. But my lord, we are having party there, my lord. My lord, we are arrested, my lord. Lordship's order also it reflects, my lord, that we have not committed any offense. We are there, my lord.
what is this order you have annexed
Case 15.
same PS case
Same PS case. But of course, these are bail application, my lord. BA, my lord. But no commission of any of, we are having party there, my lord. They are police arrested. We fought among, my lord, us, my lord. Police arrested us, my lord. The pretext that we are there.
I think CD was not there in the
Sir, CD was there, my lord. CD was there, man.
Right. Page 15 of the para 1, 2, 3. Third paragraph for escape of word to sir. And that person is the present petitioner. So, the arrested persons have already been released on regular bail, considering the period of their detention. It is provided that event of their arrest shall be released on interim bail of rupees 50,000 to sureties of like amount. The arresting authority. Petitioner is directed to appear before the IO within a period of 10 days.
I'm obliged, my lord.
No. You won't dispose. Actually, we can dispose because what will the CD reveal more than what is already there? I think we have already seen the CD also.
May I please, your lordship? Here, your lordship will get the FIR at page 24. Some people were arrested in connection with this case, your lordship. This case relates to construction of a five-star hotel in Kaziranga, your lordship, called Ingla Pothar area code.
What is this party? Joy Bharat party.
That, your lordship, they don't belong to this party, but one of the accused arrested belong to that particular party.
I have not heard of this party actually.
Last election, your lordship, they have contested election, your lordship, different places.
But this is before
It
Congress
is,
party.
they are, your lordship, in fact, associated with Jharkhand Mukti Morcha. The party JMM, that party in Jharkhand, your lordship. We are, your lordship, this Gita Gwala, Robin Gwala, most of them are from one family, your lordship. And they are the affected, your lordship, parties. A long FIR, your lordship.
Gwala.
Gita Gwala, and your lordship, 7 of them, your lordship. Things 6 belong to same family, your lordship, 1 to 6, and 7 is Srimati Kishan. In fact, your lordship, they are pursuing, they have filed a writ petition here also, your lordship, praying for a directions from this honorable court, your lordship, that I have annexed, your lordship, the order at page 65, your lordship, for demarcation of the land. They are claiming that they have been occupying that particular land for quite long period of time, and the government official has said that those are government land, but they have the pattas, your lordship. So they prayed for demarcation of the land. That without demarcation of the land, your lordship, they are sought to be evicted, and therefore, your lordship, this whole issue cropped up, your lordship. Our prayer, page 65, your lordship, may kindly see that there is a directions from this honorable court for demarcation, your lordship. That is also there, your lordship. Within 1 month of time. Page 66, para 5, your lordship will get. And this order is dated 23/6/2026, and FIR is dated 29/6, your lordship. That not having been done, your lordship, we have protested, your lordship, and ultimately that has resulted in this FIR, your lordship. Now we went before the honorable court, your lordship, honored additional session judge, your lordship, and the honorable additional session judge granted us interim protection, your lordship. And while granting interim protection, Your Lordship, we appeared before the Honorable, the police investigating agency, Your Lordship, and our statement has been recorded. Now, Your Lordship may kindly come to page 55, where our bail prayer has been rejected, Your Lordship. Page 55, appraisal, Your Lordship. On the face of rival submissions, I have perused the case there as well as the injury report available in CD. Also perused the case record of Bokakhat PS case number. I have also seen all the video cases as found in pen drive so and so. Perusal of the CD shows that petitioners accused persons initially appeared before the IO after being granted interim pre-arrest bail, but they failed to comply with the further lawful direction to appear with relevant documents for further interrogation. Proceed. On their failure to appear, IO served them with notices for appearance as they did not comply, so the petitioners accused persons are not cooperating with the investigation. Further video footage also revealed that aforesaid petitioner accused persons, all of them except one belongs to the same family, so disproportionate aggressions toward the on-duty police personnel, including the senior police officers. Now, Your Lordship, in fact, we have been called for once we went there, Your Lordship. Thereafter, there is no notice by the authority to us, Your Lordship. Therefore, we did not go, Your Lordship. After bail rejection, Your Lordship, one person was issued a notice. That is, Your Lordship, we have annexed that page 57, Your Lordship will get it. And now, Your Lordship will kindly see, they have called us. Your Lordship will find at page 57. 31/7/2026 dated, were asked to appear on 8:30 p.m. And this notice was served on us, Your Lordship, on 31/7/2026 at 9:30 p.m., Your Lordship. We have made a specific averments to that effect, Your Lordship.
Page 6. Page 6.
Page 6, Your Lordship, our averment, Your Lordship. That the accused petitioner most humbly submit that the FIR and omnibus and general one naming 13 persons together with about 50 other persons. Para 5, Your Lordship. That's
So the learned court had granted anticipatory bail, but only on the allegation of IO that they are not cooperating, it was cancelled. But according to them, they did not receive any notice. No, that was considered. That was considered. I think he mentioned unnecessary what? Unnecessary aggression. But it does not say attack or something. Connect counsel for counsel in application under potential. Allegations primarily involve those of creating disturbance threatening of construction workers and assault on police party, causing injuries to police personnel in course of an incident. What was this site?
Ingle Pothar, Your Lordship.
Hmm?
Ingle Pothar in Kaziranga, Your Lordship.
Ingle Pothar, Kaziranga. Now, some project is going on.
Yes, yes, sir. 5-star hotel.
Where a 5-star hotel project was underway. It appears that the petitioners had earlier approached the learned court below and were granted interim protection, and they had also appeared before the IO. But due to subsequent alleged non-cooperation with the investigation, the order of interim protection was vacated. It is the submission of learned senior counsel that after the petitioners appeared before the IO, their statements were recorded, they did not receive any subsequent notice. Any notice on any subsequent day for their appearance. Therefore, they could not appear. For the CD, having regard to the above, it is provided that 1,100 each. Petitioner shall appear before the IO in a period of 10 days from today.
Deeply obliged.
May please, Your Lordship. POCSO matter, Lordship, notice will go, Lordship. Case there.
POCSO CD and notice to respondent number 2. Deeply obliged.
It pleases me. Anticipatory bail application, Lordship will find FIR page number 13. Allegation here is that 2 numbers of cows were seized from a vehicle, a swift vehicle, 4-wheeler vehicle. 2 numbers of cows were seized, and specifically it is stated that it is reasonably suspected that the cattle are stolen property. That was the allegation. Now it is not named. It is against unknown persons. Now, how the police, after almost 56 days, they could not hold the real culprits. Now they are linking me with this case on grounds that they have found a driving license on this vehicle. Now what happened actually, I have also stated in paragraph 4, 5, 6 and 7. Now at one point of time, I used to be a driver of this vehicle. Almost 2-3 months prior of this occurrence of this incident, now 2-3 months prior, that owner of this vehicle was arrested in some offense, and I left the job. Although I was a part-time driver, I left the job 2-3 months prior to this incident. Now what happened, my almost in a due course of time, I used to keep a copy of my driving license in the glove box of that vehicle. Now the police, has got that driving license, and they are, after me on that ground, or merely on that ground that I have found a driving license on this vehicle.
What driver will leave their driving license in the vehicle?
Absolutely, that is what I have stated in my affidavit, because in the next day when the police comes with that plea, my credibility will go. I agree, Now I might have inadvertently, left that driver's copy, because all of a sudden the owner got arrested, That's the very reason I left the job, And also, I was not a full-time driver. Whenever the owner got a ride, he used to call me, and that's it. Nothing else, And it's 56 days, the cows have been recovered. Lordship will find the seizure list at page number 14. The cows have been seized, Now 56 days, interrogation can also happen without my custodial detention, I totally agree with that, A driver will not forget driving license, but that is an inadvertent mistake, Just because, that owner got arrested in some heinous offense, I had no other way but to leave the job, and that can be a mistake, of course. Page number 18 is the seizure list, and they could not show that how that cows were stolen. They have just said that it is reasonably suspected, nothing else.
Anyway, this FIR is of 12/6. You can wait for 2 weeks. CD.
At this point, my lord, at the interim protection may be
You
granted.
have been here for 2 months and have come, so what is the hurry now?
Can it be a little earlier, my lord? Yes, my lord, an interim protection may be given that he has.
Yes, next.
Yes, my lord.
Yes, what is this?
May I please, before lordship? Yes, my lord, by police, my lord, in action by the police, SP Borpeta. And the case is, my lord, a dead person giving an ally position and taking this chance misappropriate some property. This is the case and which we have filed, my lord. We have filed this case 25-6 to SP, also informed to SP Borpeta. After all, on 24/7 also we have submitted a complaint against OC for inaction.
Have you approached the CJM?
My lord,
The police is not registering your case.
till SP by, before SP are not CJM, my lord.
Government advocate.
May I please? Petition of revision petition filed against the order dated lawsuit 6/6/2026, however, the petitioner was filed a Jimma for 8 number of cattle lawsuit. And thereafter, the learned GMFC SDGM lawsuit, Biswanath lawsuit reject the Jimma only on the ground that whether the accused is entitled custody of the said cattle would be brought on record during the trial lawsuit, and also accused is facing trial. And here in this case, lawsuit kindly says page 33 is the impugned order, lawsuit, 11%. As the present petitioner before lordship, he purchased 8 number of cattle lordship from Gauhati cattle market. Out of 8 number, 4 number of cattle purchased from one Nandeshwar Dole lordship, and another 4 number of cattle was purchased from one Moneshwar Basmotari lordship. That is a receipt lordship, that is page 25 from page 25 cattle purchase lordship. And while transporting the cattle, the veterinary officer also issue a soundness certificate lordship, that is page 30 lordship. Lordship, in this case, I have filed this revision petition only on the ground that while the learned trial court reject the petitioner without considering the fact that the petitioner is the absolute owner of the cattle and he produced the original cattle purchase receipt. And second lordship, the trial court also failed to record it satisfying that there is enough material to presume that the prima facie offense under the Assam cattle presumption has been committed or intend to commit by the present petitioner. The case was registered lordship. In this case, lordship, section 13 and subsection 1 of Assam cattle presumption reduce section 11(1) subsection 1 A, B, C, D of provision cattle to attack the section 13 lordship. Subsection 1 of the Assam cattle one has to prove to contravene the provision of section 4, 5, 6, 7 and 8. Here in this case, the bare pressure of the impugned order lordship.
Those are we are not concerned with. We are only concerned with the legality of the Jimma order.
Lordship.
Who are you? What is your stand?
As they have been, now that is under trial. Yes, it is probably around 20 of. And the observation of the planet magistrate also.
Oh, no, you are only a third party who has been given custody for the time being. So what is your say here in this matter?
Because we have the any fighting for the last 6 to 7 years against this one of cattle preservation active. 11 for the entire inspection figure, where as per clause 11(5). On is being satisfied that. Another act. Or interested to communicate. Full convenience is check it out. So, there is a bar in the also, vehicle can be on the.
Vehicle has been released, I think.
Vehicle release.
And it order, मतलब period that the case the third paragraph in the method. Case 36 third paragraph. In the method in hand having 8 numbers of category transported in bolero pickup vehicle as mentioned in the FIR. As such, transportation was violative of the rules, making the transportation of cattle clearly will be. Moreover, interim custody of the 8 number of has been given to given credit to the foundation. So, the 4526. The organization has not created any unwillingness to accept the sub-custody. Now, although the legal system generally presumes that the owner is the applicant custodian, there is allegation of 20 against the accused person who is claiming that the fixed settlement is lawful property, and hence under the given section circumstances, at the dispute of the opinion that the matter of whether the accused of the owner of the property is entitled to custody. Later decided on the basis of the evidence brought on record during the process trial. The trial is subsided fiction for appearance. So it is the same person in the when there is a specific bar in the accused and the presume no goods vehicle can get.
Please. Then discuss.
Next week. See the case. Against the. Part. Allocated a plot of land near Gauhati. He has a registered animal welfare organization also. And so much judgment. It shows that the in this particular in this category, the Gosala, the animal welfare organization has the focus to resist focus to selling orders from the owners.
May I please, Your Lordship. Here in this case, Lanet PP submit that the as per section 13 Lordship, there 11 something to 5 Lordship, there is a bar Lordship. But when the order was impound order passed, they have the Lanet trial court magistrate has to pass a set to record a satisfaction whether there is enough material to presume the victim, but there is no any satisfaction recorded that there is enough material against the present petitioner. There is no any satisfaction which is required, Lordship, as per section 11. That is a presume that that prima facie there is enough material to presume that the prima facie offense under this section there must be a satisfaction. And the second lordship, regarding the Zimma lordship, kindly see the judgment I have produced before you lordship, manager Pinjarapal Devda lordship, and para 19 lordship. Here in this, I'm married lordship. In view of the above discussion provision of section 450 of CRPC, it appeared to us that unless the owner of the animal in respect of which he is facing prosecution is deprived of the custody, which can be done only on his conviction lordship under the act for the second time. If he is a convict under
What act is this?
that is lordship, the judgment of manager Pinjarapal and another.
No, we are asking what is this act?
That is cattle preservation lordship. Cattle preservation act.
No, in this Supreme Court judgment, is it an Assam case?
No lordship. And coordinate and another judgment is a coordinate bench of this honorable court lordship, that is Sirajul Islam lordship, that is granted Zimma lordship, that is paragraph lordship, 7 lordship. Sirajul Islam lordship, that is para 17 lordship. Para 7 lordship. Para 7, Sirajul Islam lordship, the coordinate bench of this honorable court judgment lordship.
Para 7 of what?
Para 7 of Sirajul Islam judgment of this coordinate bench of this honorable court judgment lordship.
Where is that?
I have produced lordship. I have also highlighted lordship. There is I have submitted 3 judgment lordship. One is manager by Pinjarapal lordship, and another Sirajul Islam, and another Bharat Amratlal Pathari lordship. I have highlighted lordship all this all the paragraph lordship.
Where does this judgment deal with that provision pointed out?
Plus para 9 lordship. It is to be here noted that section 11 section 4 provide that the one receive of the report, the judicial magistrate first class may on his being satisfied that there is enough material to presume that a prima facie offense under has been committed, release the seized matter include the vehicle conveyance except cattle on furnishing of bank guarantee equal to the value of material or vehicle conveyance to the satisfaction of the court, pending resolve of the criminal proceeding instituted in respect of the alleged offense. Para 10 lordship. A careful perusal of the aforesaid section reveals that the word may use in the aforesaid section is not mandatory, and it is discretion to left with the trial court below that, but the court below has failed to consider the same. Further, it appears that the learned court below has failed to record its satisfaction that there is enough material to presume that a prima facie offense under the Assam Cattle Preservation Act 2020 has been committed or intended to commit. The case was registered under section 13 of the Cattle Preservation Act and section 11 of the Prevention of Cruelty to Animal. To attack section 13 of the Assam Cattle Preservation Act, one has to contravene the provision of section 4, 5, 6, 7 and 8. A bare perusal of the impending order revealed that no such certification is recorded by the court below. Without recording such certification, it cannot be said that the impending order so passed by the learned court below would stand to test the legality, priority, and correctness. Here, in this case, it is the same also. There is no satisfaction recorded by the trial court also. In this case, on para 15 lordship, the 14 number of cattle was released lordship. And also one of the judgment lordship, para 12 lordship, cited lordship, Bharat Amrit Khatari lordship. Here in this case, para 12 lordship, in the Bharat in this case, papers, this court is the court to answer the question whether the respondent 1 to 6 are entitled to relief of interim custody of goat and sheep pursuant to the filing of complaint number so number 7 registered with the Desa City Police Station. The fact that respondent 1 to 6 are the owner of goat and sheep is not disputed either by the appellant number 1 or by the contesting respondent. Though the respondent what has by filing counter reply point out that the official of Punjapal at Patna are taking best care of the goat and sheep in the instead case, this court find that keeping the goat and sheep in the custody of respondent would serve purpose of none. Admitting the respondent 1 to 6 by vacation trade in goat and sheep. Probably a period of more than 1.5 years has elapsed by this time, and by production of goat and sheep seized before the court. The prosecution cannot prove that they were subject to cruelty by the accused because no mark of cruelty would be found in the trade in which the respondent 6 are engaged is not prohibited by any law. On the fact and circumstances of this case, this court is of the opinion that the respondent would be entitled to interim custody of goat and sheep in the case during the pendency of trial, of course, subject to the certain condition. And the case lordship, the present petitioner lordship, he transferred. There is no any bar under the Assam Cattle Preservation that the seized cattle cannot be granted Jima during the pendency of trial lordship. There is no any absolute bar. Lordship. May word is used may lordship.
That is there. Was may, but there is except cattle with specific.
May is in relation to the either items, may or may not release them. As far as cattle is concerned, complete bar is there.
The vehicle means the vehicle, but that's for the except specifically mentioned.
Here in the case lordship, the may also lordship omitted lordship.
As far as your contention regarding non-recording of satisfaction is concerned, already it is charge sheeted, cognizance has been taken after recording satisfaction. So 11/6/26.
But owner, Supreme Court says that another principle the owner can be deprived only on conviction lordship. In manager principle case lordship, only of second.
That is not dealing with the Assam Cattle Preservation Act, with separate law. It was only with CRPC, that is the general law, and the PC Act. Here the charge is
And
under different sections.
And point the lordship, cattle was transport lordship. There is a soundness certificate also issued by the veterinary official lordship. I have annexed lordship.
Documents of the number 2 here, Lordship. These are and in addition to that, I have submitted many judgments of the Honorable Supreme and some judgments of the High Court. In a similar situation, I'm saying that if the owner claiming owner is accused and he's not answering for the custody of the cattle during the judgment of state of unity versus mistaking the judgment and another latest judgment is subject versus state of Maharashtra. It is in this judgment specifically mentioned if the cruelty, then it cannot go to the judgment of the decision versus state of 2020. There is a judgment of Surat of 2021. There is versus state of Assam, and it has been upheld by the Honorable Supreme Court. As on today, Meherbanu the law, because the proposition made by this Honorable Court has been upheld by the Honorable Supreme Court. And
in this particular judgment, Madras High Court has laid certain observations. Lordship. In the present case, the documents at the time of FIR and seizure, Lordship, sequently they come up with all the documents before the Congress. They will doubt about their claim, Lordship.
No, they produce lordship because while
But
the first
still
what
Lordship, he
Why-
clearly speaks that there is no seizure.
because at the time of the they are not refused to verify the documents. They subsequently they appear arrest and they produce the document. The learned trial court without follow the Zimma report lordship reject the petition. Regarding the accept lordship, there is a notification lordship. The accept is omitted lordship by the. Can you see the notification gazette?
Manu's husband was. Paragraph 27 onwards.
There are two Meher Banus. That is the Supreme Court.
That is the affirmation from the.
Regarding the.
I did not.
ठीक है follow.
Paragraph 27 also. If I may read also. Here the petitioner has claimed to be the owner of the state documents. Okay, situated at Dinaspur, West. How a doctor from Assam then. And thereafter also rule 56 with bold letters was no goods carrying more than 6 cattle. Yes, not to speak about the goods carrying vehicle, a small vehicle of Mohindra Bolero pickup losses. 8 numbers of cattle. And there is specific allegation how the cattle were carried. And at the request of the police laws. I am reiterating lots for the last 6 to 7 years. Young Foundation has been working in Assam and India, been fighting against this everything single-handedly. In Assam, we have got the support of paragraph 33 onwards. Everything has been made, and that has been upheld by the Honorable Supreme Court. During this trial also, as observed by the learned trial court.
Appellation. Regarding the Meherbanu case lordship,
Just a moment.
there is a subsequent miscellaneous case was registered lordship. In this case, Honorable Supreme clarified that the cattle of Jimma may be decided during the by the trial court lordship. In the miscellaneous case, I have not present lordship.
Trial court has decided. Oh.
During the.
No, I remember
there
this
is
is
one-
coming back. I have an occasion to go through Meher Banu and Dhyan Foundation, perhaps when I was there.
Regarding the lordship, the section element subsection except lordship, except is omitted lordship as per the gazette notification. I have produced the gazette notification lordship.
What gazette notification?
I highlight the lordship. Here, section 5, there is bars except that is omitted lordship.
This is recent, 22.
22.
That has been omitted in the 8th line lots, but we are concerned about the 5th line lots.
So can you see the book lordship?
No.
Can you see the book lordship? Book to साथ में होता है लिखी दिशा मैं तो book तो मैं publish करना kindly see the book lordship there's a star mark lordship there's a section 5 star mark lordship except
The amendment of two laws. This is the line in subsection 5 in 8th line. Eighth line has, it has been omitted also, but we are concerned about the fifth line. Already there.
Subsection 5 of a section 11.
Yes.
Yes.
Eighth line, yeah.
Eighth line, 1, 2, 3, 4, 5, 6, 7. Where is 8?
To the satisfaction.
Except to the satisfaction of the court. Except kettle, that is on fifth line, that is not. Kettle on furniture, that is on fifth line. The eighth line. Vehicle oblique except to the satisfaction of the court. That except in the eighth line has been omitted. And what except in the sixth line there is, that is not an omitted one.
Both there is a star mark, Lordship.
Mark, Malak.
Except for that star mark. Well, this is
There is two word except. In the sixth line, there is except. In the eighth line, there is. When there is on the eighth line.
This book is pre-amendment. So here in the fifth line, except kettle, in the fifth line, except kettle is there.
This is after amendment, Lordship. That book is after amendment, Lordship.
This book is after amendment. So after the word conveyance, it says
there is no except, Lordship. Star mark.
this is omitted. That except is committed. No, not eighth line. On the full, in the eighth line, where is the word?
This is the word, Malak. Equal to the value of material of the.
Let's go by the old act. 1, 2, 3, 4, 5, 6, 7. Eighth line is pending disposal of the criminal proceedings instituted in respect of the alleged offense. Where is the except? Huh?
Old act.
Yes.
Old act.
Old act that except. You are saying referring to the word except in the eighth line. 11.5.
Old act amendment, Lordship. Old act amendment, Lordship. Old act amendment, Lordship.
Before the amendment, the word except is only in the fifth line.
Yes. I produced the Gazette notification already.
The Sigma in the Gazette notification.
Yes, this eighth line word is except.
Yes, two except on the.
This second except appears to be superfluous, meaningless.
Yes. Subsequent Gazette, not because of. Book,
Book, I think we cannot rely on now because the Gazette notification is there. It may be an editorial mistake. Because the line says eighth line and here it's in the fifth line. I think this book is also wrongly published then. The word except in the second, it's not there.
This one a prior amendment.
Yes.
This book is after amendment, Lordship.
But this Gazette is after amendment.
Two Gazette notification before us. One is.
This is Gazette notification of. This is the original act. And gazette notification says 8th line. So only the 8th line except goes. The present except stays. These books are misleading.
And submission on the basis of books listed, with the books listed.
I think you should catch hold of the author. I think there is a confusion because of which this.
Maybe for double accept. I have already produced the gazette notification. No, Sirazul after the may use Sirazul has there is a clear list the accept what is there Sirazul is. No. Sirazul does not likhe as accept quotation.
Going by the book, they first came across the word accept and then omitted it. Yes. Otherwise, it would not have been necessary to mention 8th line. But because of this, it has turned. But this is only 8th line.
But may what is there, Lordship? The may the judicial may on being satisfied, Lordship. If it is there must be some satisfaction.
That is what we have already expressed our mind. May is in relation to. Yes. All right, we'll see.
Much about.
Yes. I think it is this bunch.
I have produced the judgment or I have already marked, Lordship.
Yes, we have seen.
His judgment, Lordship, on whose Honorable Supreme Court judgment, one of the Honorable.
Yes, all are there. Save it.
Item 14.
Item financial 17.
17 is today.
Government advocate has come. আহাৰ পিছত মাতিব।
May please, Lordship. And in this matter, my senior will appeal, Lordship. Today he has some personal difficulty. Any other day?
The appellate court has directed to make the payment 20%. Against that, they have taken.
Apparently, he does not think it is simple, so he wants his senior. All right.
There is an interim order, Lordship.
All right. Interim order passed earlier to continue.
Okay, hearing item number 9.
I plead your lordship. I was arrested on 11/5/2026. Today, lordship, 89 days behind the bar, lordship.
What is the section?
POCSO is there, lordship. POCSO 4 is there, lordship.
4 is there. What is the statement?
FIR at page 11.
Victim statement is there.
9 days, lordship, kindly consider.
Huh? What is the age of the accused?
It's 40. Accused 48 years.
48. Charge sheet. Charge sheet.
Nine days, lordship, kindly.
59 days. What is 59 days in respect of an offense of this nature? Yes, you are for
89 days, lordship.
89.
89 days. Yeah. 11/5/2026.
Then
5.
so what is the point now? I also had 59. But check calculate the date. If it is 89, we can have it on Monday. Matter will become easier. List again on Monday. Leave it on Monday.
Please, your lordship. Pending for service, my lord. You're supposed to obtain instruction.
Additional PP submits that no instructions have been received as regards service of notice on respondent number 2. Is the matter again on so and so when on it
What detail of
prosecution shall obtain instruction.
Can it be on a shorter date? It's been already pending for 2 months, my lord.
Give a short date. Okay. Get on the phone.
Deeply obliged. Search sheet has been laid. Search sheet may be called.
Charge sheet submitted. What do you want, TCR?
Yes.
This is NDPS.
Yes, Your Honor.
CS file so and so submitted. Number, give the number. Call for scan copy of TCR along with CD. Yes.
Bless.
Paste again. Give it date.
Let's say if a bit earlier, just earlier than 21, if possible, as per your lordship's convenience.
This is the point 2-3 days you are arguing. Differential 2-3 days make.
Obliged.
Charge case, DNA to Lordship, here it is a charge case now. The TCR has already been called for. And here the dispute is regarding the paternity. The accused is saying that he is not the father. So, but the police took his DNA sample, but the DNA sample of the baby has not been collected. And it is under 376.
Then what is the point?
Lordship?
Then what is the point of taking DNA if the...
That is why, Lordship, the DNA...
Then it is not relevant at all. Huh? That is what, why are you looking for the DNA report now?
Because
if there is no possibility of matching.
Now, Lordship, he is behind the bar for 76 days. And already the charge sheet has been submitted. He has been implicated in the FIR. But here the girl was staying in different homes at different point of time, even before the lodging the FIR, 9 months before lodging the FIR also. So we have stated in para 8. Lordship, now if any stringent condition, considering the length of detention and the fact that the charge sheet has already been submitted, I may be allowed to go on bail.
Baby has already been delivered.
Yes, Lordship. And FIR was lost 2 days prior to the delivery of the baby only, not before that. Suppressed her pregnancy also.
Trial has not commenced.
No, Lordship. The sheet was submitted only on 36 2026. By charge sheet number 36/26. He's collected all the evidences. At this stage, further custodial detention may not be required in my humble submission. That is there, Lordship, but I have denied the paternity on the day one.
Where is the baby now?
Baby and the girl is in the custody of an NGO called Sokhi. Because her parents and the father here named is her stepfather. He was in different places as domestic helper that I have stated in para 8. On any stringent condition, Lordship.
Well, difficulty, I think, with taking the DNA sample of the baby was because before 3 months it cannot be taken. That is the report. Now 3 months will be over soon.
On any stringent conditions, because she is in the safe custody of an NGO, recognized NGO, and I'll not, I can give the undertaking that I'll not go to the vicinity of that NGO. On any stringent conditions, because here I'm a victim of a conspiracy.
But we'll see. I think there have been cases I have come across where High Court has also ordered for DNA.
And Supreme Court has
Hmm?
Supreme Court recently has ordered by Justice Koteshwar Singh and another that the right to privacy, and in order to make a balance, the DNA's order of the DNA was upheld. The sampling was upheld.
All right, we'll see.
May I please your lordship, my lord, office in the NDPS intermediate quantities, my lord. Already 47 days. On last occasion, when a matter came up before your lordship, lordship directed the people to bring the consent letter of the accused who agreed to search by the police who conducted the search, my lord. Because it was not there in the city last occasion. In the meantime, also my permission one is that even I have found out in my FIR that the search was made by the police officer, who was not a gazetted officer. On that account itself, the search becomes illegal, my lord. That is one aspect, my lord, in my case, my lord. The compliance of section 50 was not there, my lord.
So any written consent is available.
But that was not there, I think, but even if done, my lord. But that was again at the time of when the search was made, my
You furnish those documents.
The reading body that not.
Huh? All right, Monday we'll take up. Let him. We can't see there what is there or not.
I'm just pointing out one that the search itself was conducted by the police, who is not a gazetted officer, man. He must be a gazetted officer, man. That the Supreme Court, Honorable Supreme Court judgment also there in this regard, man. I am allowed to place it before lots of man.
We'll examine all of that on Monday. You bring that on Monday. Additional PP submits that he has received the instructions and pressed for some time to place the same before the court. Is the matter again on Monday or Tuesday? Tuesday. All. Tomorrow and day after is holiday. Tuesday.
Net visual. 26. No, here, my lord, fight between husband and wife, my lord. They've been living separately, my lord, for last 2-3 years, my lord. Yeah. No, he is inside, my lord, and if possible, my lord, there was an altercation, my lord, and the fact, my lord, some injury in the tussle, my lord. But some, he ought to join his place of posting also, my lord. Page 25, my lord, we have annexed his. So he'll be terminated, my lord. Page 25, we have annexed his ID, my lord. And he is. Family members got this notice, my lord.
Yes, you submit your written explanation that you are in jail.
If it goes, my lord, his family.
You have not yet been placed under, this is AB.
No, my lord, he's inside, my lord, around a
So
month.
B, so you should have been under suspension.
Yes, my lord. Now, my lord, if possible, my lord, because husband and wife, my lord, some alter, because they married in the year 2009, my lord. Two children, and children were staying with the informant, my lord. Thereafter, my lord, sometimes they used to come to the accused petitioner's house, my lord. For that purpose, definitely, my lord, some altercation was there, my lord. She stated something, and here, my lord, both the section, my lord, earlier 325, 326, both have been attributed, my lord. 1 month in custody, more. Possible, my lord.
When were you arrested?
9/7, my lord.
31 days.
So how many? About 30 days.
My lord, more.
Exactly
Huh?
More, yes.
Exactly 31 days.
On that day itself, my lord, date of incident itself, my lord.
No, 30 days.
30 days, my lord. We'll ask him to make a move for reconciliation also, because
Para 12
para 12, if your lordship can have a look, my lord, we have stated also, my lord, page 7, my lord.
No grievous injury is mentioned. Injury is on the palm.
Palm, yes.
Third learned counsel for the petitioner learned additional PP. An application under so and so. As per the complaint, the petitioner assaulted his wife after an altercation and attacked her with a sharp dagger with the intention to kill and caused deep cut injury on her left palm while she tried to defend herself. Where, counsel for the petitioner submits that considering the length of detention of 30 days and the nature of the allegations, the prayer for bail may be considered. It appears from the forwarding report that the witness furnished evidence that he was assaulted by a sharp weapon, but no mention of any grievous injury is made. So, investigation of the case has been completed. Charge sheet has been submitted. Regard to the above, as well as period of detention of 30 days. Further detention may not be. It is directed that the petition be released on bail of 50,000 to securities. Section of jurisdictional magistrate. Further provided that the petitioner threaten or intimidate the victim in any manner. Allowed accordingly.
Much obliged. I look.
In this case, not TCR was called for, my lord. And the petitioner, my lord, he is in jail, my lord, for as on today, my lord, 215 days, my lord.
NDPS.
NDPS.
Commercial.
Commercial.
Huh? Love up to something.
My lord, the petitioner before your lordship is a lady. She is behind the bar for 53 days. Intermediate quantity, 79.55 gram allegedly recovered. And my lord, she is a pregnant lady, 5-month pregnancy. 53 days as on date, my lord. It was allegedly recovered from her residence.
Arshid? TCR is not received.
No, no, my lord, this is investigation.
What is not received? CD is not received.
My lord, because 53 days by Tuesday, it will be. She's a pregnant lady, my lord. Otherwise, no police remand is also sought for. I have annexed the pregnancy details at page 26, your lordship may see. 26.
We'll see on Tuesday, yes. Learned additional PP. CD not received. Learned additional PP. Press for another date. List the matter again on.
This case there was called for lordship and I am behind the bus last 84 days lordships. Offense under section 152 and 3094 of the BNS.
Received. Is the FIR?
84 days. Bis number 13. Yes, lordship. Bis number 13 lordships. May I read lordship? With due respect, I beg to state that while I was going towards my home, Ulubari, in front of the Guru Nanak school, one unknown car stopped at the right side and forcefully pulled me in a four-wheeler vehicle, threatened me and snatched the 50,200 rupees from me. Unfortunately, I know one person of these persons very well. The name of that boy is Asif Ali alias Minto. Thereafter, they pushed me off the left in full speed. Though I have seen every details of the vehicle is Eon white color, vehicle number so and so. Therefore, your kind authority
Yes,
is to
PP.
investigate the matter.
So where, from where he was carrying that money? He coming out of an ATM or something? No. He says nothing about where he brought the money from. Because had it been 1,000, 2,000 rupees with normally that we carry. Normally a person doesn't carry 50,000 rupees in his pocket. So some history is required, otherwise it gives suspicion of false implication. Third learned counsel for the petitioner. Petitioner PP decision application under the allegation is that the accused three unknown persons possibly took the informant into a car and took away rupees 50,200 from him and then dropped him from the vehicle and fled the scene. The petitioner, the informant has identified the present petitioner as one of the said three, and on that basis he was arrested on 14/5/25. Where permits that the petitioner may be released on bail, the ground of length of detention. Where learned additional PP perusal of the CD permits that the victim has identified the petitioner as one of the accused. That may not be admissible. Perusal of the CD, however, there appears to be no explanation as to how the government was carrying such a huge amount at the relevant time. Having be that as it may, having regard to the period of detention of 54 days and regard to the nature of the allegations, therefore bail is allowed. Right. So you are appearing. So we not issue notice now. Already had learned counsel for the petitioner and Mr. Learned government advocate. It is submitted by learned government advocate that he shall take instructions as to why the FIR has not been registered. List the matter again on data.
Awesome, list.
But due to non-availability of scanner, मला गर्दी दिसते आहे समजा. Last order मला 14/8 30 one 51.
It is recovered from him.
No, my lord.
Recovery is from him.
Actually, my lord, the petitioner, my lord, he's a professional driver, my lord. He works under some.
Anyway, it's from your.
Yes, my lord.
At this stage,
Actually, my lord, at the time of incident, my lord, he was told that the owner's vehicle, my lord, has been hired by some Ranjan Kolita, my lord. The present petition, my lord, he did not know, my lord, as to whether, my lord, any contraband will be carried or not, my lord. My lord, he has done his duty only, my lord. Being a servant of a master, my lord. This is my lord, already, my lord, 215 days, my lord. He will cooperate. He will face the trial, my lord. Yes, my lord, he is being two minor children, my lord. They will suffer.
those are not the questions. We have to come to the satisfaction required under section 37. Just trying to see in what condition it was. Where is the FIR forwarding?
Forwarding is at page, my lord. Page 12, my lord. 13, my lord.
It was recovered in gunny bags from dashboard and everything. How can you say you are not aware? Had learned counsel for the petitioner. Learned additional future decision application under so and so. The effect of the case is that the police acting on prior information set up a checkpoint. Where is this national highway?
No, my lord.
Gorchuk.
Pamohi Road. Gorchuk Pamohi Road.
At the Gorchuk Pamohi Road. And in course of checking intercepted the way one Alto vehicle been driven by the petitioner and recovered. What was the total?
There are 2.281. Calculated,
32.89 kg of suspected ganja from different parts of the vehicle. It is submitted on behalf of the petitioner that the petitioner was unaware about the contents of the containers in bracket gunny bags, and he was driving the vehicle on the instructions of his employer, that is the owner of the vehicle, which is a commercial vehicle.
Right. Yes.
It is also submitted that the petitioner has now spent how many days?
215 days.
Huh?
215 days.
50 days behind bars. Sarah Learned additional submits that the trial is yet to commence and witnesses are yet to be.
For evidence on 14th.
Trial has commenced otherwise. The trial has commenced and the matter case is now fixed for further evidence. And there is sufficient material to indicate the involvement of the petitioner. On perusal of the material on record, it appears that the recovery was made from the Alto vehicle driven by the petitioner. And the suspected ganja was stored different places of the vehicle like boot, BWT, boot and seats and dashboard. Full stop. Considering the above, cannot be said that the parameters set forth in section 37 of the NDPS Act have been met. So in other words, this court cannot come to a satisfaction that the petitioner is not guilty of the alleged offense. Accordingly, the prayer for bail stands rejected at this stage. Send back the TCR. Yes.
May I please, Your Lordship? Well, there are two petitioners, my lord, Puneet Agarwal and Manish Agarwal, my lord. Manish is an employee of the Puneet, my lord. Now, Lordship will find this is a trap case where the CBI investigator, they have apprehended 21 case, my lord. Lordship will find the relevant at 21A, my lord. My lord, there's a deal between the public servant and one Mr. Informant, Mr. Mohammed Matlebuddin Ahmed, and Mr. Chauhan. He has demanded some money from the Matlebuddin, my lord, after the execution of the war. And the money was supposed to be paid at the residence of the Chauhan at Jaipur. By through Hawala transaction, my lord. That was the initial plan. That is revealed from the FIR itself, my lord. Even note, Lordship knows that generally in the Hawala transaction, the currency notes was used as a. So that was also forwarded. In the FIR itself, it is in the third paragraph. He demanded 12 lakhs from the informant.
Yes.
So in the FIR itself, it is revealed that there is an initial plan, my lord. The Chauhan has demanded to the Matlebuddin that the money needs to be paid to his original house at Jaipur, my lord. And accordingly, mobile number, the currency number also been exchanged. Thereafter, my lord, there is he could not go to his own residence at Jaipur. Then what he has directed, we are also working in the same NHI, my lord.
We are very small contractor, my lord, also doing some work in the, we basically we run a toll book. So he has the Chauhan, he has directed Mr. Puneet to basically collect a file. That was the exact conversation, my lord, as far as my instruction, collect a file from so-and-so that Chauhan has directed. And accordingly, just one day before, that is on 30th June 2026, just one day before. To collect this exact wording is Chauhan called us the ek aadmi four file dega tum le lena. That was the exact wording given to me instruction. So accordingly,
Where is
Puneet has directed the Manish to collect the.
Where are you reading from that conversation?
As per my information, my lord, the client has said that this is the exact wording. They must have that conversation also in the case diary. In the case diary, definitely they are having, my lord, because they have trapped the conversation also been recorded. So accordingly on 30th June, my lord, this was the direction. Accordingly, my lord, the Puneet has directed his employee Manish to collect the file. So he gone there, he collected. Then the person said there is a cash of rupees 4 lakhs. So he has again informed the Puneet that this is instead of 5 there are 4 lakhs rupees. So accordingly, then itself we have been apprehended. That is the case, madam. It's a basically trap laid down basically for Chauhan. We are no way connected. Nothing. We just followed the instruction of the Chauhan. And if Lordship knows this is a trap case, and the whole we are already 37 days in the custody, these two persons. Otherwise,
Who is the other one? You went to collect the money.
Yes, ma'am.
The file.
Yes.
The other person.
Other person who directed the employer. Same firm. Same firm, my owner.
Petitioner number 2.
Yes, madam.
Manish Agarwal.
Puneet and Manish, madam.
But how are you? Who asked you this Chauhan?
Chauhan is the main person, madam, director.
Chauhan is the government servant.
Yes, he is the government servant. He has directed. He knows it.
So how are you connected to Chauhan?
Because we used to work in the same NHI, we are the small contractors. So he said that 2 files will come down. You collect these 2 files, madam.
All right, yes.
So accordingly, we have been apprehended, my lord. So voice sample taken, everything. Mobile seized. And the lordship knows it's a trap case. Must be there is a pre-trap, post-trap memorandum. Everything has been seized. The electronic evidence, they have seized everything. I am in the custody, and my instruction is that I was in the police custody for 2 days. And from 3rd July, there is no further interrogation in the jail, my lord, by the investigating authority, my lord. And they have filed their objection. Primarily, they are saying that my release will hamper the electronic evidence, my lord. That is the primary objection. In the para 11, they said, my lord. So originally it was a demand and the trap was for the Chauhan, my lord. Last moment it was changed because they are supposed to, their own FIR says the whole money was originally planned to deliver at Jaipur through Hawala transaction. But the Chauhan somehow, he did not get to Jaipur. He was somewhere else, Shillong. So he has directed us to collect on his behalf.
Yes.
Matter related. He has certain negotiation. Is out, it's more than a crores of rupees. the petition. Within that lesson district. As well as a huge person has been taken. Please check.
So what has all that got to do with their custody? No, your scientific forensic evidence, voice sample and all that, what has it got to do with their keeping them in custody? They will go to FSL. Huh? Where is this Chauhan now? In jail or free? Custody. So main person is there with you. Yes, go on.
As a guide to process. He has sent it out of rupees. Paying number so as has been collected from the WhatsApp.
No, Chauhan is not before us. All this pertains to Chauhan and the informant.
Not to us, man.
Chauhan has given it to the complainant.
Yes.
This is the bail for other people. That part you need not repeat. I have heard it for the fourth or fifth time now. That part is clear. Okay.
Any conspiracy not be hatched in the his mobile number belonging. Jackson to send the the Anand Singh job provided the contact.
No. Don't take us through the entire thing. We were primarily we are now concerned simply with the fact whether the custody of the present petitioner is required any further. You confine your submissions to that. Don't take us through all the hundreds of pages you submit. Larger conspiracy.
The original.
I was waiting to hear that word from you.
Yes.
Larger conspiracy. I'm surprised that's not mentioned here. Yes. Anything else you want to, by way of documents you want to submit in addition to your already there? All right, we'll see.
He's a joy of the consortium. In one to listen.
Yes, all right. Mm. To examine whether their custody is required.
Checking is there, what?
That is what I was asking. Do you want to submit anything else in addition to your objection? You said everything is there. Yes, send it over.
My contention is very valid. The custodial detention and from their admitting the original plan was true, the entire money Jaipur through Hawala transaction. As because he could not, we have been instructed to collect. That is our only involvement. Admitted fact, madam, in the FIR. That's all, madam. Obligement.
Yes.
And there is no, my lord, interrogation from 3rd of July, madam. Obligement.
May it please your lordship. Lordship, this is a regular bail application. Here, this petitioner in jail custody for 10 days, lordship. He is the lordship recipient of some goods, lordship, kept by one Amit Kumar, lordship. I have given the photographs of this person on page 26, lordship. Otherwise, this petitioner has a lordship registered dam, lordship, running a dam, lordship, in the name of our mother, his mother, lordship. That license, lordship, I have annexed here. That Amit Kumar lordship come with this material, lordship. Specific allegation against other person, lordship, prime case, that is on page 17, lordship, with the FIR, lordship. Recovery already made, lordship, 4.35 kg of copper, AC copper pipe, lordship. So already recovery is made, lordship. And this person is for default of another person, he is the victim of the circumstances. I have kept photographs, annex, lordship, page 26, lordship. This person, lordship, requests this petitioner to keep that material, lordship. That's why I took his photographs along with lordship Aadhaar card. Otherwise, he could not escape, lordship.
You're just a baby, aren't you?
That, lordship, I have escaped, lordship. I have no knowledge, lordship. These materials are stolen properties, lordship. The dam license, lordship, will find on page.
What license?
That is the lordship scrap dam license, lordship. That is on page 25, lordship.
All right, we'll see. You search is submitted.
That may be kept as a.
Then we have to get it. Scan copy.
Lordship, tomorrow is the date fixed for his marriage, lordship. I have applied for the lordship registration of the lordship.
Somebody is still willing to marry you.
Yes, lordship, because he's an innocent, lordship. He's not a theft, not committed any theft, lordship. In FIR, lordship, specific name is the other person, lordship, not against this petitioner, lordship. Only thing is the recipient of the stolen property, lordship. Page 9, annexure 9, page 33, lordship.
Unfortunately, we didn't ask you to fix your date of marriage, so we don't feel very responsible. Okay.
Considering, lordship, already material has been recovered, lordship.
When? How many days now?
Today 10 days, Lordship.
Yes. And copy of TCR.
Eight. From Kamrup Metro, Lordship.
Is the communication submitted by IO be kept as part of the record?
Hello. Is the interim of any date, Lordship? It's published.
Yeah, please, Your Lordship. We have filed this IA for correction in the bail order. Lordship may kindly come to page number 9, Lordship. It was written down to the satisfaction of learned CGM Kamrup Rongmia. That will be SDGM Rongia Kamrup, Lordship. That is the only typographical error. And Lordship was pleased to allow 2 bailers. One each is required to be inserted. That much all. That page 9, Lordship, of the IA. Paragraph number 6, Lordship.
Yes.
It will be SDGM Rongia Kamrup.
IA 804 of 26. Hard Learned Council for the Unlearned additional people. This IA has been preferred seeking correction of certain errors that has crept into the order dated 04/08/2026. Bail application 1995 of 2026. Full stop para. In paragraph 6 of the aforesaid order, stated that the bail bond is to be with 2 sureties of amount. Bail bond of rupees 20,000 with 2 sureties of like amount. The satisfaction of the CGM Kamrup, Rangmia, RANGMIN. Whereas the satisfaction is to be that of the SDJM Rongya
SDGM Rongia Kamrup.
Kamrup. And the word each, EACH, to be inserted after the words sureties. Accordingly, the aforesaid order stands corrected and the same shall paragraph 6 of the said order shall read as follows. Having regard to the above simple. Therefore, bail is allowed on furnishing a bail of rupees 20,000. Here it is each of like amount to the satisfaction of the learned. Yeah, Kamrup. Will read as part of the order 04/08/2026. I stands disposed.
I am highly offended.
May I please, Your Lordship?
My lord, here, my lord, two items 56 and 57, my lord. They were arrested on the same day in connection with the same case, my lord. My lord, background of the, my lord, item number, my lord, 57 is different, my lord, as per my instruction. Instruction is that, my lord, police went to, my lord, item number 56 petitioner, my lord. And at that time, my lord, incidentally, my lord, this 57, my lord, petitioner was with him, my lord, just. Accordingly, my lord, very casually, my lord, as per my instruction, he was also arrested along with him, my lord. Therefore, my lord, here in this case, my lord, apart from the merit, my lord, arrest procedure is also not followed, my lord, in this case. And my lord, item number, my lord.
You are on item number 56.
Yes, my lord. May be taken up serially, my lord, 56. Here, my lord, they are not named accused, my lord. One accused person was arrested, my lord. He was driver of the vehicle, my lord. And immediately, my lord, he was arrested and forwarded. Regarding, my lord, FIR, my lord, page 12. And it is stated, my lord, quantum, page 14, my lord. 556.72 gram of suspected brown sugar without plastic box, my lord. And this man who was arrested, my lord, with contraband, his name is, my lord, Nazrul Islam, son of Abdul Suban of village Kapilapar, Pure Karihana, PS Lanka, district Hujai. He was arrested, my lord. And subsequently, my lord, these petitioners before your lordship were arrested on 14/1/2026, my lord. Yes. Here, my lord, lordship, I have annexed their forwarding report, page 16, annexure 2, my lord. These two persons, my lord, they were arrested on 14/1/2026 at 10:39 p.m., my lord. And dear, my lord, arrest memo, my lord, page 19, annexure 3, my lord. It is there, my lord. But when, my lord, this, my lord, notice under section 47, page 20, it was, and my lord, notice under section, my lord, page 48, section, my lord, page 21, my lord. Here grounds are, my lord, not furnished, my lord, as per their, my lord, convenient language, and, my lord, they are, my lord, as per law, my lord. No material facts are, my lord, described in the ground, my lord. And they are, my lord, not named accused, my lord. Page, my lord, 20, my lord.
20 is 47.
47, my lord. And page 21, my lord, 48, my lord. In this regard, my lord, I beg to, my lord, furnish, my lord, some judgment before your lordship. Lord, I may be allowed to refer, my lord.
What is the material otherwise, PP?
My lord, this brown sugar, my lord, alleged. Here, my lord, in both the cases. But my lord, they are not in the, my lord, that is. Expert, my lord. There, my lord, they find, my lord. So these are the persons who are, my lord, involved in the transaction.
Found from what? Found from what? Other than statements of co-accused?
Apart from that, one my lord. Five of them, my lord, this is the my lord. Number 6. Our statement is also there.
He's an accused.
But she is not an accused, she is the wife. Now, my lord, regarding my lord, the second adequacy in my lord. I can, my lord, produce the. My lord, regarding my lord, the third part, that is the violation. Being out from the my lord, there. According report, my lord. Where the time is my lord. 10:39. For the both my lord, excuse me. My lord. In the form, my lord.
Yes.
10:39, my lord, PM. That part is my lord, PM. Now one is my lord, AM, my lord. Another one is my lord, PM.
Which is AM? Where is the AM?
Well, AM is not there, my lord. But both are my lord, sorry, my lord.
All are P, huh?
All are PM.
All are PM.
All are PM, my lord. Then that mark, my lord, this is the medical examination also. In the my lord, 11. That part of my lord, violation. Adding my lord, the in that regard, was my lord, that all the my lord, revision page.
Especially, my lord, item number 57, my lord. My instruction is that, my lord, police approach, my lord, item number, my lord, 56 petitioners, my lord. And incidentally, my lord, as they are local, same local, my lord, he was found, just his casually. There is nothing against him, my lord, no, nothing, my lord. And so far, my lord, petition number, my lord, item number 56, my lord, police went to him, my lord, as per the, my lord, statement of the co-accused, my lord. In this regard, my lord, I have submitted, my lord, to judgment, my lord. Turning page, my lord, page, in the, my lord, compilation, my lord, page 42 judgment, my lord, I beg to refer. Is judgment, my lord, from the first page, it is judgment, fifth judgment, my lord, page 42. 52, my lord, referring all the judgment of the Honorable Supreme Court and our court also, my lord. At paragraph 14, my lord, page 46, my lord, it was, my lord, held that, my lord, that as per, my lord, ratio laid down in the Tufan Singh, my lord, that, my lord, on the basis of co-accused, my lord, accused may not be detained, my lord. And another recent judgment, my lord, the serial, my lord, page, starting from page 51, my lord, and the relevant portion, my lord, paragraph 12, my lord, I beg to refer. It is page 55, my lord.
Yeah, for that you don't have to give any judgment.
Yes,
Statement of co-accused. But from what I understand from the submissions of learned PP is that there is other material besides The
But
statements of
my people, my lord, from the CD will say, my lord, but regarding, my lord, item number, my lord, 57, my lord, there is nothing, my lord. Even except, my lord, wife of the, my lord, accused number 1 made one statement, my lord, but there is no evidence, my lord, to this effect, my lord.
Evidence will come only during the trial. We are now on material.
Then, my lord, I have referred to judgment, my lord, regarding that aspect, my lord. Only, my lord, the statement of the wife of the petitioner of item number 56, he was detained, my lord. There is no other, my lord.
Is there a judgment saying wife's statement is not to be considered?
My lord, it is, my lord, statement of the, my lord, some other, my lord, person, he was
Not a co-accused, it's a witness.
witness, my lord.
Then, anyway, yes,
Next
next.
one, my lord, regarding ground, my lord, I have submitted judgment, my lord. My learned friend, my lord, referring some recent judgment of the Honorable Supreme Court, my lord. Here, on those judgment, my lord, Supreme Court held that, my lord. Actually, my lord, on those two judgment, my lord, accused of that appeal, my lord, tried to, my lord, take advantage of the Bihan Singh Kumar, my lord. But Honorable Supreme Court held that, my lord, my lord, racial laid down in the, my lord, Bihan Kumar, my lord, was completely followed, my lord. There are series of, my lord, grounds was provided when, my lord, accused was arrested. Even then, my lord, they approached, my lord, to take advantage of the, my lord, Bihan Kumar judgment, my lord, but Honorable Supreme Court declined, my lord. And, my
Differ
lord,
from facts to facts, what ground
Yes,
has
my lord.
been
yes.
offered?
And, my lord, recently, my lord, Sunam Raghuvamshi, my lord, my learned friend also, my lord, referring, my lord. Here also, Honorable Supreme Court held that, my lord, it is a, my lord, unique case, my lord. She was fleeing away, my lord. She was absconding, my lord, state to state, my lord. And everybody knows that she knows also very well, my lord. Thereafter, my lord, giving some, my lord, grounds, my lord, she was arrested, my lord. And it was also held, my lord, on our Supreme Court that, my lord, it is a specific case, my lord. And in this case also, my lord, Bihan Kumar's, my lord, judgment was upheld, my lord. That it does not come under the purview of the judgment of the Bihan Kumar, my lord. So in this case, my lord, ground was, my lord, not provided with the facts and circumstances of the case, my lord, where and how, my lord, they are arrested, my lord, and their language are also not convenient with them, my lord.
You submit what judgment you want.
That I will submit my. That 2 hours will come, my lord. Part is that is because obliged.
Here, my lord,
Oh, you've come again.
my lord, lordship had fixed it today. my
Oh,
lord.
okay.
Like here, what has happened, my lord? To be very honest, my lord, that trial, my lord, with all respect, a day-to-day, my lord, that has been postponed till, my lord, another schedule has been given, my lord. That relief, because that application is pending before the Honorable High Court, my lord. That application was filed, time has been given. Now, my lord, the question of liberty, my lord. That day, lordship asked me, my lord, that, my lord, it was a statutory violation, 35(3), my lord, regarding, my lord, whether it flows from Article 21 or not, my lord. That Menaka Gandhi Authority, my lord, 7 judges bench, my lord. Some, my lord, with all respect, my lord, there may be a detour, my lord, but, my lord, possibly it is there, my lord. May I just read it and place it before your lordships, my lord? Because whatever is there in the statute, my lord, that it flows from Article 21, my lord. This is a huge pages, my lord. Lordship would kindly have a look at, my lord, with all respect and folded hands, my lord. I thought that this should be pertinent, my lord. Para 7, my lord. That occurs at page 284, my lord. Dagmai, this one, Page 284, my lord. I'll begin from the last part of 283, my lord. That will be better, my lord. 283, my lord.
Yes.
283, last two lines, my lord. My lord, equality before law, my lord. Article 14 strikes at arbitrariness in state action. Arrest is state action, my lord, and ensures fairness and equality of treatment. The principle of reasonableness, which legally as well as philosophically, so beautifully said, my lord, is an essential element of equality of non-arbitrariness, pervades Article 14 like a brooding omnipresence, and the procedure contemplated by Article 21 must answer the test of reasonableness in order to be in conformity with Article 14, both to be read together, my lord. It must be right, just, and fair, within parentheses, my lord, and not arbitrary, fanciful, or oppressive. Again, parenthesis, my lord. Otherwise, it would be no procedure at all, whatever is provided in Article 35.3, my lord, Section 35.3, and the requirement of Article 21 would not be satisfied. So, my lord, it flows from Article 21. Apart from the statutory provision, my lord, the constitutional mandate is there, my lord. Of course, possibly that was your lordship's query, my lord. Because Article 21, my lord, procedure established by law.
No, Section 35 is in conformity with Article 21.
Exactly, my lord.
It is one thing to say that a provision of law is in conformity with a particular provision of the Constitution, and another thing to say that it flows from that provision of the Constitution, unlike notice under Section 48.
That
flows directly from 22. Production within 24 hours, that flows directly from 22.
Yes, my lord.
But 35, that first you have to give a notice before you arrest. All that is purely a statutory provision. Constitution does not mandate so that before arrest you have to give a notice.
Because it was, lordship is correct, my lord. But my lord, this authority, it possibly means that.
This authority only means that all state action has to be in conformity with the principle of reasonableness as envisaged under Article 21 as well as Article 14.
Exactly, my lord. My lord, this line, my lord, kindly, a student of law, I may be wrong also, my lord. What I have understood,
we all are students.
My lord.
We are students even
I'm
after
not
we
saying that, my
retire.
lord. I'm not meaning their lordship would not take it otherwise, my lord. But I'm saying, my lord, this has come out, my lord, with all respect and folded hands, my lord. Otherwise, if not followed, my lord, this is very pertinent, my lord. It would be no procedure, meaning thereby 35(2) would be no procedure at all. It would be no procedure at all. And the requirement of Article 21 would not be satisfied. It has to flow from Article 21, my lord. Otherwise, the procedural law, it has to follow from, because he'll be deprived of his liberty as per procedure established by law. Because Article 21 says, my lord, no person shall be deprived of his right and liberty except according to procedure established by law. And the procedure established by law to arrest a man in 7-year offences because of whatever is there in 35(3) or because of, my lord, 141 authority until, my lord. So it has to flow, my lord, possibly, my lord, in my understanding from Article 21, my lord. Thereafter, the procedural law, my lord. The constitutional mandate has to be there, my lord. Otherwise, the intention of the legislature, it would be challenged, my lord, if it doesn't flow from the Constitution, my lord, because of liberty, my lord. And this last line, my lord, again, I am for the sake of putting emphasis, my lord. Otherwise, if not followed, my lord, in my understanding, I may be wrong, my lord, it would be no procedure, meaning thereby 35 would be no procedure if not followed in totality at all. This is the language, my lord. Otherwise, it would be no procedure at all, meaning thereby 35(3) would be no procedure. And the requirement of Article 21 would not be satisfied, meaning thereby whatever is there in the tenor of 21 would not be followed, my lord. Both are to be in existence, 40 and 21, the contents of both, my lord. They have to be, if read together, my lord, we told that this is the, my lord, ratio. So far as that impounding of passport of Maneka Gandhi in 1978, it opened the floodgates, my lord. Because 47, 48, these are also procedural law, my lord. Of course, it flows from 21, specifically, my lord. Because Article 22, it is there. But Article 21 is so huge, my lord, it all embracing, my lord. It covers this aspect also by the parting line, my lord, in my understanding as a student of law, my lord. And here, my lord, what has happened, apart from, my lord, whatever be there in the constitution, my lord, 35(3), my lord. Now, my lord, chances have been given that the dates are fixed in the month of, my lord, new schedule has been given, my lord.
15 September.
কিমান? কোন তাৰিখৰ পৰা কোনাই নকওঁ, নিচিনা কথা কওঁ। My lord, it begins from
3rd August.
No, 3rd August নহয়. Now it will end on 15/9, my lord. Or in 7-year period offense, my lord. Whatever be it, my lord, even if he is convicted, my lord. Only this much, my lord, lordship would kindly 51 days in custody, my lord.
Victim examined already.
And my lord, the prime concern, my lord, of the prosecution that has been addressed, my lord, the victim,
Another 8, 9.
Another 8 witnesses, inclusive of, my lord, victim and mother, examined, my lord. This is my highly obliged, my lord. I may have answered to your lordship's query, my lord, partly maybe, my lord, but as I have found that, my lord, this is only available, my lord.
Partly or fully is not the question. Question is correctly or incorrectly.
Oh, my lord, I have
So,
placed it, my lord.
yes,
You
you
would
have placed
decide
it.
correct or incorrect, my lord.
We should not decide it in a hurry.
Yes,
We'll-
my lord. Yes, my lord.
We'll
Yes,
think
my lord.
about it.
Yes, my
If
lord.
necessary
Yes,
for
very
the
much.
purpose of this.
I am, my lord, absolutely in agreement with your lordship. Article case, my lord.
They were not there because on that day itself, they were examined, I think, last day.
Examination. Till now, 9 witnesses have been examined, my lord. Let it be on record, my lord. Out of 14, 9 have been examined, my lord.
We had called for the updated scan copy,
My
but is it available?
Available,
But that was the copy we had earlier. Today, no fresh copy has come. Because it was also very short.
Only that much may be short for, my lord, as to how many witnesses have been examined, my lord. If it tallies with whatever I have stated, my lord, then possibly we stand a chance. Only that much, my lord. Even the copies need not come, my lord.
Submission of prosecution is otherwise.
My lord.
That the deposition is necessary. That is your submission.
That is his understanding, my lord. Here, what has happened, my lord? Duration is very short, my lord. The last date of evidence that has been fixed is 15/9, my lord. So, that may should be on record, my lord. Here is the learned gospel words, my lord. Too legible.
Since now the trial has been postponed, what is the difficulty with if we have the scan copy now?
My lord, only thing going out, if it will be short, the 15/9,
Yes.
my lord.
15/9, we'll get it next week.
My lord, my lord, my lord, my lord.
Third Mr. Learned Counsel for the petitioner. By the last order dated 4/8/2026. The updated scan copy of the TCR containing updated depositions of the witnesses were called for, but the same has not been received. Where it is submitted on behalf of the petitioner that by now 9 witnesses have been
Exactly, my lord.
Out of
Nine.
9 witnesses have been examined, including the informant and the victim. Therefore,
Not informant, my lord.
Not in
Mother and victim, my lord.
mother and victim.
Victim's mother, question, no?
Victim, mother and other.
Victim's mother and others, my lord.
Informant not yet.
Informant is different, my lord.
Informant is different.
No, whether informant examine question, nahi. Informant has not been
Including
examined.
the mother, victim and the mother of the victim. Accordingly, the learned. Where is this case now? Special Judge POCSO.
Metro Kamrup, Dhubri, my lord.
Special Judge.
Special judge, my lord.
I think it's additional session judge Dhubri, judge come special judge POCSO is the according the additional learned additional session judge come special judge POCSO Dhubri is directed to forthwith transmit the updated scanned copy of the TCR inclusive of the depositions of all the witnesses recorded as of today. This shall be done before the next date, well before the next date fixed. Registry is directed to communicate this order accordingly. Is the matter again on next Thursday?
Can it be little bit preponed, Tuesday?
He has to come.
Oh, my, yes, ma'am. Any Thursday, my lord. Kindly Thursday. my lord.
Holidays tomorrow.
13th, my lord.
Saturday, Sunday. All right, Thursday.
13th, my lord. With all respect, my lord. Highly obliged, my lord.
Petitioner was arrested on 9/7, my lord. My lord, kindly turn to the page 17, my lord. 17. My lord, from the same forwarding report, my lord, one of the co-accused filed a bail petition, my lord. The Honorable Court observed that bail was allowed, my lord, the conscious possession was other person, my lord, yes, my lord. So I am also in the same, my lord. Kindly turn to the page 16 and 17, my lord. And 62.63 gram heroin was recovered, suspected heroin. So the main accused person is not come, my lord. Whose concise possession in forwarding report also mentioned from the concise possession of so and so was, my lord, recovered. That is not I. Page 16, my lord.
CD has come.
But in forwarding, clearly mentioned, my lord, page 17, first paragraph I am reading, my lord. After complying with the legal requirement under section 50 of the NDPS Act, a personal search of the apprehended person were conducted in the presence of the independent witnesses. During such search, 51 plastic vial contain and brown sugar powdery substance suspected to be heroin were recovered from the conscious possession of Mustaqim Ali. Of his conscious possession from his body. And this person, he was in the vehicle, he is not ever the and no case in his life, my lord, such type of offense. He is simple cultivator, my lord. Only, my lord, that similar relief may be given, my lord, as the time. It is from Santari Pier. It took shock. Fourth, my lord, allow the co-accused.
But he was in a different vehicle. There was mention of any notice. Plus that CD was, in this case, CD was received.
Another bail application.
Yes. On perusal of the CD, it was seen that there was no document to show compliance with section 50. That is why. So CD will reveal same thing. Again. Order dated 4/8/26. Para 1. নামটা চেঞ্জ করে দিলি। There are 3 last line riding motorcycle এটো কাটি দিব। Para 4, para 5, next para, co-accused of the case, namely Harudhan Ali, was granted bail aforesaid ground by order dated 04/08/2026 in bail application 1942 of 2026. Para 6, number of days?
Yes, ma'am.
Number of days?
For this 30 minutes. Today's 30 days. 30.
7, 8, 30 days, kali 27.
One thing, my lord, here the satisfaction of special judge Kamrup Aminga will be, my lord. Perhaps in earlier order, just mentioned CGM, my lord. But record is there. I have
President Judge?
special judge Kamrup Aminga.
Or case to reference to the dilo. Itu para 5 or agot dibo after para or para 5. Oh,
I'm obliged.
yes. That is what we have inserted.
I'm obliged.
LCR was available on last occasion, Lordship. LCR was called for, Lordship. In pendency, Lordship, charge sheet was submitted.
And copy of TCR not yet received. Issue reminder list again on. You did.
Interim order is there. Interim order is there.
Tell him to continue. CD not received into again on.
Nice.
Please, your lordship. This anticipatory bail application, lordship, and in this case, lordship, charge sheet already been laid, lordship, and TCR was called for, and TCR perhaps lordship and you. Otherwise, lordship, there is the love affair between the boy is 20 years, lordship, and the girl is 17 years, lordship. They have the love affair for last 1.5 years. And after 1.5 years, lordship, there is some dispute is arise, lordship, and during their relation, lordship, there is the good relation, and both the families are known, lordship, and their marriage is supposed to be solemnized after 10 days of majority. It is admitted, lordship. But subsequently, lordship, and the lordship, and kindly make consider the 183 statement of the victim, lordship. There is nothing any adverse, lordship, against the present petition. Only 20 years boy, lordship. Let me draw. Both are the lordship and same school student, lordship. Dolgoma Higher Secondary School. Same locality, same village.
Seventeen-year-old.
Lordship. So I'm providing one Supreme Court order, lordship, very short order, lordship.
She said she went voluntarily, had intercourse voluntarily, everything voluntary. But they refused to marry. That's all. Yes, what is your stand?
Involvement in this case, lordship, the otherwise, lordship, that is toward the.
It's mentioned that there are. Secondary, your lordship, as stated in the. Started 1.5 years, 2 years back. He around 15 years of that. Comment, he's a daily. Others are very severe.
Do you have any say now that the private counsel has appeared? No, since price, they have, you have filed wakalatnama. We are discharging you. And this is because of delay of 3 years, it was held to be
It is
abuse of process of the court.
Lordship, it is the up to 1.5 year lordship. They are in relation lordship. So within this period, there is no any dispute at all lordship. But the lordship and the informant party lordship pressuring the present petitioner to get early marriage lordship. But that is why lordship this dispute is arise. Otherwise, their marriage will be solemnized lordship and as per the instruction lordship. Charge sheet or
He doesn't want to marry you anymore, it seems.
lordship, charge sheet already been submitted. So lordship
He wants to keep you in jail.
will be face the trial lordship and any stringent condition lordship. Otherwise, there is nothing lordship. And 183 statement is very clear lordship. How can lordship and
At the
charge sheet late lordship and he will face the trial lordship. And during the most of the case lordship, during the trial lordship, they are settled and subsequently abuse of the court time lordship. So, my humble prayer lordship and their marriage will be solemnized. It is true lordship. 17 years and 20 years boy lordship. Force, inducement, threat is not there lordship. Anything else lordship? Nothing. Any stringent, he will be face the trial. Charge sheet or will late lordship.
Some other trial.
Not this with this case.
They
lordship.
have
That
mentioned
is-
here there are no.
File affidavit.
Else will happen.
what is the information regarding this trial? Is there any?
Charge sheet already been late lordship. That is the TCR lordship.
No, he has submitted another one.
At your lordship, your lordship.
He may have been acquitted also, then you can't call it a criminal antecedent.
Trial is going on.
Not filed any objection in this regard, have you?
It's very hard for him.
This will not do because we do not know what is the, as long as he says you, there are no criminal antecedents.
That is the lordship. No purpose will be served lordship at this stage that because he's faced the trial lordship. Condition may be imposed lordship. Any condition.
We'll see.
Deeply obliged lordship. Deeply obliged.
May I please, Your Lordship? Petitioner is an interim lordship. FIR in page 8 lordship.
Yes, what section is there?
3084 lordship.
Huh?
3084 lordship.
and 351-2. 351-2 is bailable, Lordship, and 3084, Lordship, it is an extortion. But here, this section is not attracted against the petitioner, Lordship. In the FIR, Lordship, informant states that multiple threatening message and blackmailing messages came in his WhatsApp, Lordship. But 3084, Lordship, states that
No, now such sheet has been submitted. What do you want to do? Do you want to appear there or?
Lordship, may grant Lordship absolute, Lordship. Let me here, Lordship. Lordship, kindly see the interim order, Lordship, passed by this honorable court, Lordship. Order dated 16/6/2026, Lordship.
Now I don't think his custody is anymore. Because it has been filed means you don't, no further material is to be extracted from him. Order dated 16/6/26. Para 1, 2, 3, 4. An additional PP submits that the charge sheet has already been submitted. Submitted that you have appeared.
Yes, Lordship.
In protection granted by this court, the petitioner had appeared before the IO and his statement also recorded. Having regard to the above, the fact of completion of investigation, the custodial interrogation of the petitioner longer necessary. The prayer for pre-arrest bail is allowed. Order of interim pre-arrest bail dated 16/6/26 is hereby made absolute. It is further provided that the petitioner shall cooperate with the trial. Charge sheet has been, and in this regard, he has received communication dated 2/8/26, which is kept on record.
Highly obliged.
My lord, I am in interim bail, my lord, and already our statement has been recorded. So, I will see. MFI.
Hmm? Not required. They have appeared in this 39 and
39 and 40, they have appeared as the
39 and 40. Third learned counsel for the petitioner and learned additional PP submitted by learned additional PP that the instructions have been received that the custodial interrogation of the petitioner is not necessary. Accordingly, the instant bail application, instant pre-arrest bail application stands disposed of by making the order of interim pre-arrest bail dated 26/06/26 absolute. Item 39 and 40.
appeared, my lord, they have also.
So what is your difficulty in furnishing
No,
the?
that is not with me, my lord. They are forced me to, my lord, and that is not with me, my lord. That is a document, my lord, their document, my lord. Only photocopy is with us, my lord. So a photocopy I have produced before the court, my lord, in the arbitration case which is going on.
Which is that?
Which is arbitration case is going on. That is the, my lord, in the FIR, my lord, that what there is a there's lots of litigation going on, FIR, counter FIR, one arbitration case is going on, and that arbitration case, my lord, I filed a resolution of the partnership deed was produced. Now they say that that is false. That is why case has been registered. In FIR page 25, it is very reflected, my lord. Your lordship kindly see FIR was registered on that one. In fact, my lord, FIR was initially not registered. After 18 days, it was, my lord, registered. So in fact, my lord, the compromise of the Rodda side is also going on.
How it can be raised.
On that separate subject matter, my lord, but it was a, now they say that it is false, which was I submitted in the arbitration case, my lord. And they say that they came to know from the arbitration case. I am the defendant in the arbitration case, my lord.
Number, my lord, 1299. I could not proceed.
This is the between Puspa Majang and these other parties. So how do you know with whom the original is now?
No, we already statement has been recorded, my lord.
If she says it is not with me, what is to be done? It is with them. So what is your suggestion now? And during this period, this will turn up magically. Hmm? You are representing whom?
Page 35. The relevant page is 39. Is the relevant.
This is a different deed than the one which was shown, page 54.
Coming to the partnership deed, page 35, I am on bail petition number 1. Page 30, my lord, if you can enough to see para number 8, page 39.
I am holding 1299. Hmm? 38. This is what, 37. Oh, that
This is page 32, my lord. The partnership deed.
Hmm.
Page 36. Para number 8 at the bottom. These are the partners. I'm just trying to clarify, Lordship, why this issue has arisen. From Mahjong, my lord, the last one is 1% of the partnership holder, and these are the 5 partners. So these people formed a partnership. From Mahjong is the shop, which is a liquor shop. Business continued, whatever differences arose between them, my lord, there were some FIRs filed, whatever happened. Subsequently, my lord, I also filed an FIR to say that there are certain problems that has happened between the partners. That I invoked the arbitration clause under this agreement and filed a section 9. That Pushpa Mahjong, who is also a party, filed a reply and document saying that the partnership that you are relying is now being dissolved, which obviously, according to me, my lord, I stand corrected. I am not aware of a dissolution. Now comes next is the dissolution. Talking about today, which seems to be the bone of contention. I said that if that is the situation, I am not aware of the dissolution deed. The dissolution deed came to me. In terms of the dissolution deed, my allegation has been the fact that since I am not the one to bring subject matter of this dissolution, obviously the responsibility of them to say that this is their dissolution deed. So I had got that in the section 9. And because when I saw it, I realized that these are not my signatures. I have not executed it. That is my case, my lord. I send it for my satisfaction and evaluation in Delhi. That I have brought in my objection. Say that now the report says that none of the signature are matching. Let me say one said, my lord, that I have done this mischief. I am obviously sure, my lord, any person who first decides to do this would not have his own signature mismatched. If I am doing it, this is my general understanding of the fact that if I have done the dissolution deed and I have not disclosed it for example, let us take this situation. My signature cannot be wrong in that manner. The others could be copied, no problem in that. So the general understanding is that it must be done by them. So that is the allegation. The bone of contention is dissolution deed, which I am saying is obviously not with me. Otherwise, I would have never filed that section 9, or I would have never said the partnership is exist. That is the only. Therefore, I was requesting that document would have to be. I am saying I don't have it. He's saying he doesn't have it. We'll have to rely on this photocopy, my lord, which is being filed, which he is also relying. I am also relying, my lord. That case, some order will have to be passed, my lord, whether to say whether this document is right or wrong, or whoever is done. In my case, I have a slight edge to say that I have done my part and I've realized this is not my signature. So that was not produced by either of them when asked, because the original is not with them. My case is obviously I have not done it, so I do not have it with me.
So the FIR that you had lodged.
Yes. Isn't it so that
alleged forgery?
Yes. Saying that those are not my signature. How can that be?
Now, for the purpose of this application, if the forged document itself is not available,
the law should rely on a secondary evidence to say whether that can be first taken into secondary evidence and whether we can go ahead with it.
In a case of forgery, there is no question of secondary evidence. The original document has to be there.
Absolutely.
So basically, there is nothing to proceed. If he alleges forgery, cannot insist upon the accused to produce a document that incriminates him, is it not?
That arbitration proceeding also going on. That's
It is going on, but arbitrator may
yes.
probably not like to decide this. That is a different matter. We are not
Right.
concerned with that. But present, whether the custodial interrogation is
required or not.
necessary. That is
Already she's a senior citizen, 66-year-old lady, and her statement has been recorded already. And my lord, they are even trying to settle the matter, my lord, amicably. But I don't know why it is, my lord, success. They have every location they are sitting, my lord. I came to know, my lord. Even in fact, police, my lord, I will also call them to, my lord, settle the matter. Immediately they are a partner, my lord, in some business, my lord. They are going on Rifoi district in Shillong, my lord, and Meghalaya, my lord. All are in all.
so. What? How do you want to proceed now? Left to us, we will pass whatever order we feel is justified. Yes. Okay, IO has prayed for time. Let's see if it takes any other turn now. It's meandering along this way, that way.
And if they settle, my lord.
I stand strong on the fact that the report says the signature is not mine. That is the only.
Privately, he has, my lord, using some agency, my lord, he has done it.
They can have a discussion after visiting their own party.
My lord.
Heard Mr. Tijum so for the petitioner, learned additional PP. Heard Mr. Informant. It is submitted by learned additional PP that the IO has sought further time to trace out the deed of dissolution which is involved in the present case. The matter again on
My lord. 28220.
interim orders passed earlier
Yes,
to
sir, continue.
continue. এই তিনটা আইটেম ওঠে আইটেম 39 42 বেলেগ হৈ গ'ল বাকি কেইটা
41. And probably two are already disposed of.
yes.
May I please your lordship? Lordship, this is the second bail application, anticipatory bail application. Earlier 16 numbers of petitioner application for bail application.
Not following you. What are you trying to say?
This is second bail application. Earlier 16 numbers of petitioners apply for bail application. Then there are some not all, some are here three petitioners.
Where is the order of rejection?
Yes, for this. Level says.
So it is just a question of again whether against the present petitioner. Earlier rejected present petitioners also. Then
Present petitioner number one is a newly engaged pharmacist.
concerned about what he is doing is go to page 37, huh? Para 1, 2. Rated 12, 11, 25. Para 1, 2, 3, 4. Earlier bail application in respect of the present petitioners being as well as some other petitioners being AB 2532 of 2025 was disposed of by order dated 12/11/2025, wherein the prayer of the present petitioners for arrest bail was rejected. Learned additional PP on perusal of the CD submits that there is sufficient incriminating material against the present petitioners. On perusal of the said materials, their earlier petition pre-arrest bail application was rejected. Moreover, considering the heinous nature of the offenses resulting in the death of 2 persons, it case for grant of pre-arrest bail. And moreover, no ground has been made out. Also, in view of the above, therefore, pre-arrest bail stands rejected. Petition stands this and back the CD.
Is there, and I have already appeared before the before investigating officer.
I did not receive again on so and so interim passed earlier to continue till the next date of listing.
Obliged, your lordship.
Please, your lordship. The instant case is registered under provision of POCSO Act and Child Marriage Act, lordship. You will find the FIR on page 13, lordship. Search sheet is laid and absconder search sheet is laid. Thereafter, TCR was called for. Probably the TCR is received, lordship. There is type copy is on page 13, Lordship. Caused by the Gau Pradhan, Lordship. Lordship, victim has come into appearance, and Lordship, Lordship comes to the page 21 where the IO has narrated the brief of the case. More relevantly, Lordship, the second last para on page 21, Lordship.
Yes, we've read that.
The POXO provision will probably not come in this case, Lordship. Already the IO has commented, Lordship. It is found that she got pregnant while she was above 18 years above. Section 6 and 17 will anyway not come to the present petitioner because it is abatement. Section 6 will also not come, Lord. And regarding
Where has he said it? She was 18 years?
Lordship, page 21, Lordship. Page 21, second last para, last line, Lordship. Page 21, Lordship.
But this does not tell is what it is said above.
Yes, Lordship. But last comment of the investigating officer in the brief of the case is it is found that she got pregnant while she was above 18 years.
We will not accept that.
And
what will happen to all this?
Yes. And Lordship, otherwise also.
She got married at the age of 16 years and accordingly delivered a baby. He has given all dates and calculations to show that she got pregnant while she was a minor. And at last he says if she was above 18 years.
Lordship, if Lordship comes to page 18 for once, Lordship, page 18, here Lordship, the IO has seized two documents, which is Aadhaar and child protection cards. And it does not comply section 94 of JJ Act, Lordship. These documents will not determine the age. Only these two documents are seized, Lordship. Child Marriage Act also, Lordship, will not attract to present petitioner, Lordship. Section 9, 10 and 11. Section 9 says punishment for male adult marrying a child, Lordship. Lordship, the present petitioner was at that time, as per my calculation, he was 17 years, 11 months, 25 days. His date of birth is 6/1/2005. And other two sections will not be applicable to the present petitioner. As section 10 says punishment for solemnizing child marriage, and section 11 punishment for promoting or permitting solemnization of child marriage.
Yes, PP.
I have admittedly my minor. He loved my love with the good person.
Is it eloped or where is that? That is in this. Can copy. See, I is stating all kinds of things. He was forcefully married. And
Genuine adolescent relationship, Lordship.
during investigation, it is found victim was less than 18 years while she was married. The victim's father knows everything and he forcefully married his daughter to accused. That's what IO says
For my
in the charge sheet.
For my instruction, it was a genuine adolescent relationship. Respondent victim is present. This is our humble submission from the stronghold of law. The genuine adolescent relationship may be exempted, Lordship.
Third learned counsel for the petitioner. And additional PP also had learned counsel representing the victim. Application under so and so. The allegation as per the FIR is that page 21 first para. The investigation of the case has been completed and the IO has filed the charge sheet. It is submitted by learned counsel for the petitioner that the case of adolescent love and the victim was in a love affair with the petitioner, had eloped with him and subsequently got married after she attained majority. It is also contended that the victim had attained majority when she got pregnant. Learned counsel representing the victim also submits to the same effect. The aforesaid submission find force from the statement of the victim available in the CD. Furthermore, it appears that the documents relied upon by the IO to prove the minority of the victim are the Aadhaar card, and one mother and child protection card, which are not recognized as valid proof of act age under the provisions of the JJ Act, which are also to be followed in a case under the POCSO Act. Having regard to the above, prayer for pre-arrest bail is allowed. The prisoner so and so in the event of the arrest connection with so shall be released on bail of rupees 3,000 with two sureties of like amount to the satisfaction of the learned trial court. Petition stands allowed accordingly.
Special Judge Hojai Lodge. Deeply obliged. Please allow. This case has been registered under section 140 Lordship, subsection 3 of BNS. There is Lordship kidnapping with intent to keeping secretly and wrongful confined. Lordship, in this affair, page 8 Lordship. It is Lordship, before lodging this affair, victim was recovered, Lordship. Lordship, and now Lordship. So page 8 Lordship. In this 8 Lordship, in the last line it mentions Lordship, victim was recovered, Lordship. Lordship, though there is a delay part is there, Lordship, as per this affair, Lordship, incident was took place on 11/4 and affair was lost, Lordship, on 17/4. And that affair, Lordship, was registered on the 5/5/2026. And Lordship, victim's statement, one of the victim, Lordship, there is a two victim, but one of the victims, Lordship, statement was recorded up near about 3 months, after 3 months, Lordship, though she was recovered before the lodging affair, Lordship.
What is this note you have flag marked? This note?
Yes, sir. Another one. No, my, that is my note in the note, my. That my note, 16 my. Order, please. This my note present.
Lordship, that is not correct, Lordship. Same locally.
Neighbor.
No, no.
180 have flown to. I'll see it in the.
Hmm.
And one more thing, Lordship, is aware here punishment is 7 years. So, Lordship, notice has to Lordship under 35 PNS Lordship. PNSS Lordship, it's required, but in this case, Lordship. So, Lordship, my submission is limited, Lordship. Lordship, here victim has already been recovered, Lordship. Let Lordship present petitioners may be appeared before this IOO and and almost Lordship. So far, my understanding, Lordships, investigation almost completed, Lordship. Let the present petitioner maybe face the trial, Lordship. And Lordship, punishment is 7 years, Lordship. And Lordship, notice under 35 is not complied, Lordship.
Like they went on their own with the. They must have gone with that. Because it's not possible. Two girls to just kidnap and just take in the bus and everywhere.
Lordship.
Third learned counsel for the petition and an additional fee is an application under so and so. Page 10, huh? Facts of the case. Para, the CD has called for has been received. Perusal of the same, it appears that the alleged victims, although minors, have been recovered, and it appears that they had left with the accused. No other act of a malicious nature has been attributed to the accused. In regard to the nature of the allegations and the fact that the victims have already been recovered, the custodial interrogation of the petitioners may not be necessary. Accordingly, the prayer for pre-arrest bail is allowed. 50,000 two securities. Send back the CD.
Highly obliged, Lordship.
49.
May I please, Lord? My lord, this is pre-arrest bail application, my lord. FIR is at page number 8, my lord. So far, the FIR alleged incident occurred on 23/4/2026. FIR was lost on 27/4. Number 8 is the FIR, my lord. Perhaps, my lord, there are some joint marpit, my lord. Somebody sustained, both sides sustained injuries, my lord. So far as the FIR, my lord, there is no allegation against the instant petitioner, my lord.
You were number one.
Number one. Number one. That may be, my lord, 100, 117 to earlier, my lord, 325. That is available, my lord. 7 years, up to 7 years. Further custodial detention may not be required. Injury report already collected by the investigation agency, my lord. I will cooperate for the rest of the investigation. At any stringent condition, my lord.
This injury in respect of this victim Robiul mentions many injuries. He himself in his statement says prohar kore, that's all. There's nothing else. নুৰ আলমৰ হাতত ঘাপ মাৰে ওচৰত থকা সকলে ৰফিকুলৰ হাতৰ পৰা দাখন লৈ যায় যদিও সি লাঠিৰে মোক প্ৰহাৰ কৰে মোৰ ক'ব লগা এইখিনি লাঠিৰে মোক প্ৰহাৰ কৰে that is all nothing that so many injuries depends on the IO also what he writes ultimately. Does not mention any fracture or anything in the. These are some 4 numbers of injuries are mentioned. Edema is there and some, but no fracture of any. Nothing of that sort is indicated there. The other one is also lacerated injury. This is also, but he mentions as grievous. That is that is of course private hospital. Learned counsel for the petitioner. Additional PP is an application under so and so. Page 13, para 12. The CDS call for, along with injury, medical report has been received. Medical report indicates lacerated injury on one of the victims and head injuries on the other victim, but no fracture is indicated. The statement of the victim itself does not indicate any grievous injury having caused to him as alleged. Having regard to the above, the prayer for pre-arrest bail is allowed. Petitioner so and so shall, in the event of his arrest, 50,000 to securities. Like the CD.
Value.
My PP has informed that this charge sheet has been filed, my lord. So I will reply.
Pardon? If some mention was made.
The mention my friend has appeared for the private respondent, my lord. meantime, my charge sheet. So I will file for regular bill, my lord. Before the appropriate court.
So you want to what, withdraw?
No, no, this charge sheet had been filed, also will record the charge sheet number. In the meantime, I will file my regular bill.
There. Learned counsel for the petitioner and learned additional PP also had learned counsel representing the respondent. The additional PP has stated that the charge sheet has been submitted by CS number. Learned counsel for the petitioner submits that he shall appear before the learned court below and apply for regular bail. So we close it not in view of the above. The present bail, pre-arrest bail application stands closed.
Obligations.
Lordship, the matter relates to negotiable instrument NI Act, and I am appearing for petitioner accused. The parties are in talk of compromise. The Lordship may kindly take up the matter on some other day.
This matter has been.
No payment has been made as yet. Talk is going on, it seems.
Yes.
Submitted on behalf of the parties that talk of settlement is ongoing. And similar matter pending in another court has been fixed on.
11-9.
Hence, list this matter again on 11-9. Together, let it come. Along with
2020. Yes.